good morning. I'd like to welcome everyone to the Thursday, October 25, 2012 Land Surveyors Board meeting. I spoke with Mr. Cagle Monday of this week, and he's still caring for his wife, and he will not be able to attend. He says she is improving, and he is hopeful that he will be with us in our February meeting. So we'll keep him in our thoughts and prayers, and hopefully that will be the case. We'll see that. Okay. First item of business is to adopt our agenda. Everyone will take just a minute and kind of scan through it and make sure that it's the business we intend to conduct, and also make sure that it covers everything that we want to speak about. If anyone has any additions or deletions, we'll welcome those after we look through it. We have a motion and a second to adopt the agenda as written. No other discussion? Call for the question. All those in favor? Aye. Opposed likewise? Okay. Agenda passes as written. The next item of business is to approve the minutes from our previous meeting. Hopefully each of you received a copy of those to review. Have done so. If not, if you need some time to review, we can take that time to review.
Let's give us just a few minutes here.
Certainly.
Just Tim.
No problem. Motion. Have you had ample time, Mr. Moore?
Yeah, and I second that.
Okay, have a motion and a second. There's no further discussion. Call for a question. All in favor say aye.
Aye.
Opposed likewise? Okay. The minutes are approved as written. Okay. Next item on our agenda will be beginning our legal report with Mr. Herman, who will return momentarily.
Okay. First thing, I'd like to brief the board on cases. 3 of those cases are currently in investigation. We don't have a report back yet. One of them has come back to investigations and is going to do a review or analysis, and that status will change. And the rest of the cases are pretty much on this upcoming legal report, so we're doing pretty good, keeping everything some status of progression. So that being said, we'll turn the page to this. 11 on the pad. In the first heading, there's some cases under complaint reviewers, complaint reviewer analysis.
It's all right, I can't help. Experiencing technical difficulties. It's supposed to just make us right. There we go.
Okay. Cases under complaint reviewer analysis.
That way.
I think we've got 3 of these. Well, we've had the what we've had the reviewers do is identify the authority that they believe has been violated or is an issue. Look at the materials that were submitted and compare them to those particular authorities. And then in the report that's returned to us, headline it with that particular authority and describe what, if anything, they feel is run afoul or has probable cause for the board to take action. So, case number 1 is 2012-004461. This case was referred to the contracted complaint reviewer for analysis because of the allegation of incompetence in the respondent's professional practice of land surveying and possible violation of 62.18.116, subparagraph A1B. That's entitled Denial, Suspension, or Revocation of Certificate of Disciplinary Action. And Rule 0820.04.03A, Malpractice, for producing a plat which was proved unusable for the purpose for which it was intended. Specifically, the allegation is that the respondent included enough inaccuracies that should have been discovered previously. The complainants had to hire and pay for another land surveyor to provide a correct plat. This caused a significant delay in the complainant's ability to obtain a building permit and build a house on the property. That's the outline. Case materials were forwarded to a complaint reviewer for analysis to identify probable cause for discipline, if any. This person found one, which doesn't seem to be of much consequence to the allegation. And that rule is 0820.04.071H1, survey types and requirements. Quotation from that rule: a notation on the survey map or survey plat should state whether the monuments were found or set, and in addition, the statement should include the material and size of the monument found or set. Alright. The case reviewer states that the real problem was that the respondent provided a site drawing showing an incorrect building setback of 25 feet instead of the correct 50 feet from the rear property line. The respondent admits this mistake, which caused the complainant's architect to redesign the house for the site. The replacement surveyor's plat is dated November 10, 2011, but as of March 16, 2012, the complainants still don't have electrical power routed to the site. The other allegation seems to involve the difference between the respondent's prepared plat and the replacement surveyors. The differences on the common lines range from 0.43 to 1.63, and there's a note. And the reason I put this note in here is because our respondent is represented by counsel. This matter was litigated in General Sessions Court earlier this year, in which the court dismissed the entire case, finding that the complainants were not damaged by the respondent. That case is over and done. So my recommendation is the reviewer recommends that the board take no action and close the case. And a lot of that's based on the fact that the courts didn't find any problem with the plat that damaged the complainant. On the other hand, you're free to address the inaccuracies. So I'll leave it to the board to discuss.
Well, not knowing what the reviewers have been instructed to do specifically, had we been prior to the reviewer and a board member had been reviewing a like complaint, if there had been other violations such as standards violations relative to, as an example, as the one that had been mentioned, the board member as a reviewer would have brought those items to the board's attention. Now, obviously, it is in the writings that the reviewer did find at least that standard violation.
Well, I can tell you what I did. Whenever I send these out, and it's a valid point, I should have brought that up because I do instruct them. I actually send them a copy of the entire chapter of whatever I feel is being violated. And even though the allegation is based on this, here's the chapter, and compare what you're seeing to all of the standards of practice or code of conduct or whatever it is, just to make sure that something like you're saying is covered.
Well, the scenario is asimilar to what we try to do as a board when we review applications, that an applicant has to supply a plat to us. Those plats must meet our standards of practice. And just as plats are a part of a claimant's case against the respondent, those plats also must meet our standards. Correct me, please, if y'all correct me if I'm saying this wrong, but we're clearly, we're not on a witcher. We're not trying to, attack a respondent because he left a period off. That's not what we're here for. But at the same token, irrespective of whether the primary issue of the complaint is dismissed, if there are other items that should be addressed, as simply as maybe a letter of warning or caution or something of that nature, then I think that the reviewers should be attentive to that. And that's kind of where I'm coming from.
So we know that the materials were reviewed by expert witnesses in court, and the materials were found to not be damaging. But I agree. I think the fact that it got that far probably needs to be recognized with the letter.
Well, the case as it's presented tells me several things. I'm sure it tells me the same things. As there was a setback issue where you didn't get the proper facts that did cause a problem. Court didn't think it did. But then there was a subsequent survey by another surveyor that showed, in my mind, reasonably significant differences in the dimensions or the distances for the property. And then the reviewer did, in fact, bring up one statement relative to the standards. So, in my mind, there was probably something going on there on that plat, that something's happened.
Well, I think too, on that plat, if there was an error on the thing, if the surveyor had made that acknowledgement that there was an error, it still didn't cause any damage to the owner of the property. And as far as the length of time it's taken to get things done, I'm not sure that has any relevance to
evaluation was over and experts were put on the stand and all evidence was presented, is what the conclusion they apparently came to. They put their expert on, and I'm sure the other side did. This is what's wrong, this is not really what's wrong. The court seemed to think the way, it's unusual that the court would dismiss an entire case without any action.
Yeah.
So it must have been a minor thing. And they usually say something more than, this has no merit, that's what that means.
Well, my notion is, at a minimum, I think that there should be some form of letter sent to the respondent addressing the fact that there was a standards violation found in the plan.
Yeah. To use caution in this work.
Right.
You know,
That's fine.
we're aware of that.
As opposed to us just brushing it under the rug. That way, the respondent has the ability to recognize that, hey, the board is paying attention to what they
I
get.
completely agree.
You know, and you know, maybe it's just an alert, and he goes back and he picks up the standards and he kind of looks at the standards versus the plats he's turning out. It may save him being back here again.
It's wonderful that everything turned out all right.
Right.
But you should have been more careful
Should
at
have
the
been.
beginning.
Right. That's sort of where I'm coming from. You know.
I mean, we all get caught in that. From time to time, whether we make transposed figures and what have you, and errors and that kind of thing, just be careful.
It seems reasonable.
Yeah. Reasonable amount of care should have been taken. Just review it one time, probably to solve that problem.
Watch what you're doing.
Would you like to make a motion in that regard?
Well, so moved. I'll make the motion that we send a letter of caution to the respondent.
I second.
We have a second. Any further discussion? If not, all those in favor?
Aye.
All those likewise. Okay.
Number 2. 2012-01-0521. This case was referred to contracted complaint reviewer for analysis because of the allegation of incompetence in professional practice and possible violation of Rule 0820.04.07A, which is misconduct for accepting down payment for services and not completing the survey. The complainant wants the down payment returned, to which the respondent answers that the deed never closed and that because of the time spent in the field and the work already performed, that he is entitled to keep the down payment. Case materials were forwarded to a complaint reviewer for analysis to identify probable cause. Upon analysis, the reviewer concluded that this is a contract matter and the details of the contract are not known, or even whether or not the contract was written or oral. At any rate, the proper venue for the dispute is Chancery Court, and I put, which is a court of equity, which enforces contracts, or the civil courts, which is a court of law, to seek perceived damages. It must be noted, and this is sort of the important part, it must be noted that the respondent was issued a consent order for a civil penalty in 2010, which was ignored. As is our practice, we should consider this issue, this new matter. Here's the recommendation. As far as the instant case, the contract part of it, the reviewer recommends that the board close this case, but issue a consent order for indefinite suspension until the entire amount owed on the previous consent order is paid, for which proof must be provided to the board of payment, that the respondent should complete 8 hours of professional ethics courses. The reviewer also states that the board may wish to consider additional ethics courses, additional suspension time, and or additional civil penalties for ignoring the first consent order.
First question, are you at liberty to tell us what the first consent order was?
I don't even remember. It was a monetary penalty.
I think that was it.
I think
Whatever it it the first time, let's see what's
Personally, I think that the indefinite suspension sounds like a good idea, rather than trying to impose additional sanctions. As far as the first, the issues that brought this case to us is a contract issue, and it was like the fact that he didn't pay that separate first one is problematic.
I don't necessarily have a problem with the direction you're going, other than a question as to why you choose to use the term indefinite.
Until he pays it. Once he pays it, he'll be reinstated. The consent order will state, once he proves that he's satisfied the previous consent order in full, his license will automatically be reactivated without any further action. Definitely, it's not permanent. I guess it could
Why
be.
would you use that word? Because when he gets his letter, he can send the money the next day.
Well, then that's the indefinite ends. It's indefinite because he ends at the time that he finishes paying it.
Well, not necessarily if we attach ethics force to it. I think that the reason I'm saying that is I feel like that if we attach something to that, I think we should define the suspension. In other words, for example, just as an example, if we say we're going to suspend your license for 6 months, and the conditions of that suspension are payment of the fine plus whatever we might decide, if we decide that plus, and completion of X number of hours of an ethics course. And he has, in other words, his license will be suspended for 6 months, period. And he must complete those things. And if at the end of 6 months, and he has completed those items, then it will come back before this board to reinstate his license. Or it will be reinstated automatically, or however that happens legally.
Reinstated automatically. Once they provide proof, like a receipt that they paid it, some certificate that they've completed it that we have, we can reinstate. But all the documents that we send out from the legal office say, future actions against you will consider previous actions. That's why we have complaint histories.
Mr. Chair, if I might make a recommendation.
Yes, ma'am.
If you would want to give a term period for completion of a course, and you don't complete it in a certain period of time, say like 6 months to complete this course, then your credential will be suspended automatically. This is an offer of consent, so if they reject the offer of consent, you still have a formal hearing to revoke the license. So, since you may or may not agree to the terms of the consent order, if the previous consent order didn't include automatic suspension language for failure to comply with the terms of the agreement, then this consent order should have that flexibility, saying your license will be agreed to have your license suspended indefinitely until you pay the civil penalty, and if you don't complete a course within 6 months, you'd be suspended additionally until you complete the course. So you can be suspended, pay the civil penalty, and then if he doesn't complete the course in a specific amount of time, you'd be suspended again. So that would be the remainder of the term. It's just another
Okay, that's fine.
idea.
That's fine.
He may not want to be suspended. He may not want to agree to be suspended for 6 months and not be able to work, pay for civil penalty in court.
Well, we don't know, obviously don't know whom the individual is.
Right.
Could be a situation, if it's an older individual, he may just say, well, I just let my license go and forget all that.
Yeah.
But we don't know that.
Yeah.
We can't judge that.
Okay,
What did you learn?
he owes us $850.
He's owed it since
2010.
Yeah, he made a payment of $150 in November of 2002.
Kind of like Nicole's version of he keeps his license until a certain period. If he doesn't complete everything he's supposed to do, he falls into a suspension. That might be more of a motivator than agreeing to have it suspended right now until you do this stuff. Trying to beat a deadline might be more motivator.
Might well be.
Yeah.
That might be the better course of action.
It doesn't have to be 6 months, maybe 3 months, or I don't know how often the ethics course comes around, so what is a reasonable term if you wanted somebody to take a course? How long is a
Well, they
reasonable
provided,
time?
they provided each semester at, it's the University of Arizona, what's that?
I'm not sure on that.
There's one that's,
Coming online.
yeah, that we've referred folks to before.
I don't recall.
I don't recall the university.
If it's an online course, they could take it anytime they wanted to, knock it out in a day's worth of work. So
It'd be
probably a shorter term would be appropriate,
6
maybe
months.
3 months or something like that to complete the course. If they can take it on site, only 1 day's worth of work.
8
Well,
hours.
my greatest issue is twofold here. One, he's ignored taking care of the consumer. I think that he's on the edge of making his man there. Okay. Number two,
One could say
On the
that.
edge.
I'm trying to be a lot politically correct here. That's hard for me. Sue can tell you that. It's hard for me.
Yeah, it is.
On the red line.
I'm the bull in the china shop, The other issue I have with this is I'm not real sure that we necessarily want to dismiss this complaint and not be able to relook at it, Rob.
Well, that's, if we
I mean, I realize that I don't want to have any involvement, nor do I think the other members, about a matter of monies between a surveyor and the client. We don't have any issue with that. That goes to the court of proper jurisdiction. However, there's something about this that tells me that there's something else there.
Well, if we close it, we can always reopen
Okay. I just want to be able to, because this seems to be a matter that if they go to the court of proper jurisdiction and they get a judgment, positive or negative, relative to the claimant, that there's a good chance that we're going to see something back. And I want to be able to have the opportunity to still use it.
This is like when you close in a consent order agreement until they either agree to the consent order terms or went through the whole hearing process and didn't remain illegal on the staff level.
it. Well, the consent order will be based, the offense for the consent order is failure to address the first consent order. The matter of which we're looking at could be closed and open later if we hear about litigation. Bring the whole thing back.
What help us a little bit, Rob, with formulating a motion to kind of go in the spirit that we've kind of been bouncing around here a little bit.
Well, you're for collecting what he owes.
Yes.
You want him to take ethics courses. How much?
I think 8 hours is fine.
I would think so.
So the consent order is for we want our money and we want 8 hours. Now it's a matter of how much time are we going to get him before his license goes into default status or becomes suspended. 6 months?
3 months.
That would be January, right? What do you think?
Even 6 months, I'll just put it out and put it out.
If he's being ignored the consent order, he's liable to just ignore this and sue. I agree with Sue.
He hadn't earned 6 months. Lucky to get 3. Okay, so a consent order to pay the $850 and complete 8 hours of ethics within 6 months, or within 3 months of receipt of the consent order. So as soon as they have the green card back saying he received it, the clock starts ticking.
Right.
All right. So what would the motion say?
Now, do we, one other?
Execution, yeah.
Unless
Would
you're
be
not going to
received.
do one day to agree to it.
I'd be within execution. When I get the consent order back, when I get it back signed, the clock starts ticking.
Now, the question for the board then is, do we want to tell him that if he does not complete these things, license will be suspended indefinitely. But if
Definitely until he complies.
until compliance, okay. Is that it?
The last question is, how does he get it back? Does it reinstate automatically upon his proving that he's complied? I think that would be the easiest way.
When does this clock start ticking?
And I'll get a signed agreement back.
When
He
does it
signs a
take-
consent order and sends it back to
When
me.
it takes a long time to send it back?
He's got 30 days. Then the offer is automatically revoked and it goes to litigation.
And he really loses then. He don't show up this time in 30 days, he really loses, because I would think that he would be right on the cusp of losing the license.
Yeah, that
Straight up. Would that be fair?
I think it'd be
would
more
really be
fair.
given the board.
I mean, we've already gave him opportunity, and that opportunity still exists, and, you know, he's still out there.
Best you're gonna get.
Apparently, he's still practicing since he got his consent order in 2010.
Yeah. Let's see.
And we're doing him a favor by allowing him to still practice over the next 3 months and get this other stuff taken care of.
I think it's a better motivator. Give him
Because then if he
something.
doesn't, I mean, he leaves us no choice.
I agree with you.
I
Yes,
just
ma'am.
ask one question for clarification on the order. As I understand it, the request for consent order would be consent order and an agreement to pay the $850 civil penalty upon execution of the order. So you have to turn the consent order and the payment in at the same time. And complete an ethics course within 3 months, or suspension of your credential will be at the 3-month mark, is indefinite until you complete that ethics course. Or is the $850 going to be on that 3-month time frame also? Should we require him to pay the $850 up front with the execution of the order? Or should we give him or her, I don't know, him or her for 3 months to pay the $850? That's one of the indefinite time frames that I'm not sure of in the recommendations. I just want to make sure that when legal counsel drafts it, it's for your revisions.
I'll give you my opinion. He has ignored this order that came out in 2010. I think that the payment ought to be immediate. And then the rest of it will go to the 3-month period.
I agree. I just want to make sure that the terms, because there's 2 flexible terms in there. I just want to make sure the
Right.
terms. are
So in
correct.
effect, he would need to execute the consent order and pay within 30 days.
Correct.
Correct.
This is what I've got. Consent order to pay $850 immediately upon execution. Complete 8 hours of ethics within 3 months of execution, or indefinite suspension until complied. And then once complied, automatic reinstatement.
That sounds like the way it ought to be.
Thoughtfully constructed.
Make a motion, we do it just exactly as Rob.
Okay?
Statement.
We have a motion.
I second.
We have a second. All those in favor? Opposed? Okay.
Right now, number 3 under this heading, 2012-01157-1. This case was referred to a contract complaint reviewer for analysis because of the allegation of incompetence, good surveying, and possible violation of 62-18-116 and Rule 820-0820-03, the whole chapter, standards of practice. This is what I was telling you before we sent the whole chapter to the review. Producing a number of plats that fell below the board standards of practice. A total of 19 plats were involved. And there's no complaint history for this respondent. This is all localized stuff. The case materials were forwarded to a complaint reviewer for analysis to identify probable cause. Of the 19, 11 were found to be acceptable, even though in the reviewer's opinion they all appeared unprofessional, which means they had everything they were supposed to have. As far as the other ones, the following was observed. For violating Rule 0820-03.071B5, survey along the curved streets rather than constructing the curve, the respondent used bearings and distances to define the property as the right of way. Then under Rule 808200307, on 3 of the plats, there is no tie to a corner of the subdivision, a tract from which property is carved, a permanent identifiable corner, or a nearby permanent identifiable reference point. Not tied in. The case reviewer did not make a recommendation for discipline in this matter, but seems to prefer that the board discuss the findings and find an appropriate action. So, if we just simply counted them up, we have 11 violations.
Help me with that, Rob. 1 and 5 and 3, I didn't get that 11.
And the 19, 11 were found to be acceptable. I'm sorry, I gave you the opposite.
Okay.
I really would have maybe given him heartburn. Now we have 9.
Something good antibiotic.
Yeah. Seeing all kinds of things. We have 9 violations. The only good thing we can say is he doesn't have a complaint history. So let's look at our range here.
Sounds to me like there's an element of carelessness that says, I'm not reviewing my plans after I've completed to make sure everything is complete on these things. That gets behind our curve, he's rushed to get a plan out, and he doesn't go back and review to make sure that everything's on the plan like it ought to be. Transpose figures and things would be one thing, but he's leaving things off completely that shouldn't have been on there. I think that's just the way I'm seeing this thing.
Let me ask this question. It seems that the complaint was centered around, initially around incompetence. Yet, I don't see anything in the dialogue, the text that you provided us or read to us that addresses that. Did the reviewer not speak to that?
That was the allegation. But like I said, I sent the whole chapter to him to review everything, find whatever violations he thought were applicable. So the reviewer leaned more on standards of practice.
Well,
Competence means you don't know what the standards of practice are. We're not here.
well, as I read our civil penalties, it could be $250 to $1,000 per violation. So if we so choose to do that.
6218A1C. 50 to 1,000, that's right. So there you have it. It can range from, in the math people, 9,050 or 9,000.
Actually, I read that to be line C, which is 250 to 1,000. That's what I read. I read C, little c. Little c is for feet.
Yeah, you're looking at the incompetent. I was looking at violation of any rule. Okay.
Well, I think
Incompetency in the that qualifies.
I think Galen brings forth a very good point that it seems rather apparent to the reviewer that this individual was not providing very good quality product and also was missing things at the same time. So the twofold thing.
50 times 2250 would be the minimum. And 9,000, I guess, would be the upper.
What's the total amount again? 26.
9, so if we use that civil penalty schedule, it ranges from 2,250 to 9,000. For 9 instances.
Can the board look at this as, and the reason I ask this question, since the respondent does not have complaint history, can the board look at these plats as a single incident and create a penalty around that, Ross?
That's what you would like to do. Consider them all one violation.
And the only reason I throw that out is just because the respondent does not have a claim history, a previous claim history.
Yeah, but you can
That's what she had.
use that as a mitigator.
And you know, again, not knowing who or what or where, but I'm just kind of thinking, okay, you're not doing what you should be doing, but we've not had you before us before, and we're going to give you an opportunity by not being overly severe initially to kind of, you know, pay a little better attention to what you're doing.
Do a course correction.
Right, do a course correction. That's kind of where I'm coming from. Now, I don't know what the magic number might be, whatever you all think, but that's sort of where I'm coming from, as opposed to being overly severe. You know, if this situation was similar to the last situation, then, you know, I'd probably get the hammer out. But this is a different situation.
If you give him the maximum for one offense, it'd be $1,000, which is less than half what it would be if you looked at all.
Right, as a minimum.
Well, you're a very kind fellow,
Well, I'm just throwing out a thought.
but I think you have a very valid point, because he has no complaint history. And maybe this is a wake-up call.
Another thing you might want to consider is this isn't a private citizen that complained because they had a problem. This is something that we brought because somebody anonymously brought it to our attention. And we went out and collected the complaints. So he hadn't damaged anybody as far as we know.
Other than the fact that he's careless with his work, whether that would bring about damages somewhere down the line, I'm not sure. In the 4-year statute of repose, you wouldn't think it would if nothing else had been said. Nobody has had a complaint about anything. But Tim, perhaps I'll go along with that.
Well, I'm not. This isn't an arm twister thing. It's
No,
just-
I-
I'm trying to look at it reasonably and logically, so that, you know, maybe we can get a licensee in a little better conformance. That's part of why, you know, after a while we'll talk about continuing education. Part of why we're looking at the standards and an ethics course in our continuing education to help alleviate some of these things that we're actually reviewing.
That's it.
You know, so we're looking to try to make that situation better, but that's another discussion.
Complaint history, no harm to the public, or mitigators.
So the motion then should be to consider this as just a single event.
Then you arrive on a number.
And we don't have to, we certainly do not have to.
No.
That's on the record.
I know, but I think that I think you're right in this case. I think that we ought to consider that rather than hammer the guy with everything we can hit him with. If it were a repeat offender, he's done this before, or like
Yeah.
3 or 4, then
Been
I'd
sued
say,
repeatedly because
Right,
of
yeah.
boundary disputes that he helped create.
yeah, then I would say that's would be appropriate. But I agree with him. I think that we ought to be the kind of 2 years, go with the lesser.
What kind of penalty?
Well, I think $1,000. I think
That's what we're-
How do y'all get the $5,000?
That's the upper limit of one violation. For all, putting them all together with one violation, range goes down to
you all's more decide to choose.
We do have one violation, the upper limit's 1,000, which is less than half of the least of what it would be if we looked at all 9 of them. So that's where that comes from.
$1,000 is within the range of what the violation, I think all the violations should be listed except for so that, God forbid, there are future complaints. There is a past history to identify what problems were found previously, so the facts were listed out. But the $1,000 falls within the range of civil penalties for the fine. At least you could do is $250, most would do is $9,000. So anything in that range, you don't have to specifically define dollar amount to each violation.
Right.
It actually is, it helps mathematically just to formulate consistency, but in the situation with plenty of mitigating circumstances, apply it to a specific number.
I write all that into the agreement so they can see where they, and then the cover letter too, say this civil penalty is based upon, the mitigators of this and this, the fact that they considered it one violation. Always put all that in the letters. They can see it and we can see it if we pull it back out. So, cogitating. What do you think?
Other questions? Discussion?
Is it correct that education should be tied to this recommendation?
Well, at this point in time, the state of Tennessee does not offer any standards education. It's something, as I mentioned earlier, we're working towards. And it wouldn't be very appropriate to send it to an adjoining state or whatever to do that. So we're going to try real hard to get that push. Can.
I think it's imperative that we have some ethics training periodically, and we don't have that requirement.
Well, what we face, Nicole, is, as Sue has in front of us, the old blue book. That's the last time that our rules and regulations were actually printed and personally mailed to the registrant in a book format. And we have them available, obviously, on the website and so forth. And because of that, oftentimes, if you work for John Doe and this is the way John Doe does it, that's how you're going to probably do it when you get your license. And that may not always be correct. So that's why that we kind of come to the stance that we need to get better education as a part of our continuing education, so that just to give you an example, the state of Kentucky has this particular thing we're talking about, standards classes, practice, and their whole rationale was that in a 4-year period of time, you only have to have once every 4 years, but in a 4-year period of time, they reach out and touch every registrant. So when a registrant is called before the board over an issue just like what we're discussing, they don't have a leg to stand on because they have attended, they have proof of attendance, their signature, the whole 9 yards, that yes, you were in that room and you heard every rule that you're now being questioned upon why you're not doing it. So we don't have that ability in Tennessee, but we want to obtain that ability in Tennessee. And we feel like that will help lessen a lot of these complaints of this particular area.
I think people are still using that book.
Yes.
We rewrote the standards completely
I still
different.
have a copy.
Oh, yes.
Well,
Oh, yes.
It's an antique.
that whole standards of practice we rewrote, remember?
I know surveyors that still use the red and green. Seriously. But they're trying. They're trying. I mean, they've got it right there. And I mean, it's almost like a New Testament to them sitting over on their desk. They're trying to go by what the rules was the last time they had that book.
I'm sure people have had their license for 25
Yeah.
years are not going to do it any different. There are the progressives, and there's people that just they get their license and start working, and they do it the
Yeah.
same way their whole career.
Okay, let's go back to the matter at hand. I think the issue that we were discussing before we divested was, how much penalty we assess.
Again, I state, I think that the penalty should be $1,000 just for something, and consider it all as one event.
You comfortable with that, Ms. Sue? Okay. Okay, and that's your motion?
And I'll make a motion that,
You could decrease it slightly by assigning, making it $900, $100 for even though it's still an offense. I don't want to complicate it. $1,000 is good. You're an engineer, you
We have a motion to assess a civil penalty through the proper consent order and so forth that you handle, Rob, in the amount of $1,000 in the case. Do we have a second?
A second.
Okay, we have a second. Is there any further discussion?
Just one item, just to clarify, is $1,000 either on execution or in a certain time frame, and in the time frame, should a suspension is part of the order? If they don't comply within a certain time frame, I think that's to be on everything.
I'm going to say, that ought to be a standard thing. That you don't
I think we had talked about that, and that was sort of the thing.
Actually, it just goes to litigation after 30 days expires.
Well, that's after if they don't accept the consent order.
They've got 30 days from the time they receive it. So they got 30 days to scrape together the money. I usually don't give them a time period.
Okay. I didn't know if it was due on execution would be an order.
It is with me.
Okay.
Yeah.
But everybody has
This
30
is your
days.
offer, and this
Yeah,
is
there
your
is 30 days from the day you actually
Get the
sign
letter.
your little card that says you received
It's
the letter.
both an offer and an invoice.
Okay,
Right.
I understand. I'm
Yeah,
sorry.
it's okay.
I deal with a lot of boards and sometimes we allow periods to pay things.
Okay.
Sometimes we don't.
Okay, I think we
Yes,
have,
but just a little draconian.
we have a question, and so did we vote for it? I don't think we voted, all right? Let's call for the question then. All those in favor? Opposed likewise? Okay. Okay. Mr. Rob, Ms. Donna, you want to check and see if the gentleman that's coming at 10 might perhaps be outside? And we'll go ahead with one more case.
We only got 4 left.
Yeah, if it's all right with you, Rob, we'll go ahead with one more case. If the gentleman's here, or if he's here, if you want to wait just a second, if he's here, we may just break right here for a second. Okay, all right, let's go ahead and continue then, Rob.
All right, next heading is new cases. These haven't been sent to anybody. First was 2011-028461. This one was tied up for a while. Complaint alleges professional misconduct on the part of the respondent, possible violation of 6218-116. Specifically, the allegation is that the respondent, a licensed surveyor, made a number of either untrue or inappropriate statements to the complainant. Investigation was requested, which was conducted, and a report returned to this office. From that report, the following seems to be the situation. The respondent was contracted to survey some property for the complainant. In conversations with the complainant, the respondent discovered that the filed plat had been done by the complainant, an unlicensed individual, upon which the respondent informed the complainant that such conduct is not allowed by law. This caused some friction between the parties. The respondent communicated with the adjoining landowner and reached an agreement on where to set the boundary, which was favorable to the complainant. Nothing in the complaint alleges a problem with the respondent's preparation of the land survey. So basically, I think you can understand what happened here. The recommendation is either close the case or issue a letter of caution to the respondent to maintain professional relationships with clients at all times. What happened is the respondent went out to survey, or I guess resurvey, complainant's land, found out that the complainant himself had done the survey before. He was unlicensed. From there, the relationship kind of deteriorated because the respondent informed the complainant that you can't do that. But anyway, eventually the boundary was resolved with the adjoining landowner to the complainant's favor, so everything turned out great for the complainant. But he still filed a complaint against the respondent for saying bad things, which is clear to
Was that
know.
have anything to do with the letter that we have? Okay.
I find it quite interesting that the respondent is aware of a filed plat by the complainant, yet the respondent did not submit that plat to unlicensed practice.
Well, that's been replaced by the respondent's plan.
It don't replace it. It doesn't replace it. And according to our rules, it says a register for possessing knowledge of a violation of TCA Title 62, Chapter 18, or any rules promulgated. I can't hear say that word.
Promulgated.
Yeah, that too, yeah. Thereunder shall report such knowledge to the board in writing and shall cooperate with the board in furnishing such further information or assistance it may require. That respondent violated that.
Yep.
And he violated it in writing when he responded. I got a problem with that.
I think he really mishandled it.
I mean, yeah, he told his client, he told the complainant, I assume it was the client, he told him that yes, that you shouldn't have done that. But our law says he should have notified the board because he had knowledge of it. I got a problem with that guy.
What would you like to do? We have proof that he said it out of his own mouth, so we have enough for a civil penalty.
Just as I was nice a while ago, I'm no longer nice.
You ran out.
The nice ran away.
That blood
You've
pressure's
been
right
all
now.
up.
Sue said he's back.
Dr.
He
Jekyll.
doesn't some carbohydrates.
That's right.
He's crashing.
Dr. Jekyll and Mr. Hyde.
All his life and then
Really? No.
Stop Robbie and call him the chairman sick.
It's been building up and this poor guy got
First symptom of illness is rage.
That's right.
Well,
He needs to know his own law and rules.
So you're saying is the respondent in his trouble,
yeah.
whether the complainant caused all the bad words and stuff, but it's still the respondent's fault because he had one thing.
Well, the complainant would have made it even if he had just reported it to us.
Well, see,
Confronting.
if the respondent had paid attention when he received his letter from Rob, say there's been a complaint filed against you by Mr. Complainant, etc., this is what it's about, so forth and so on, his response to this board should have been whatever he said or he did, which is correct, and then he should have included with his letter a copy of the file plat, because it's obviously of some type of record. Some type of record. He should have included that copy of that file plat in his response back to Rob and said, I feel that the board should look into this unlicensed practice. And he would have conformed with what the proper conduct of practice is. And he did not conform to the proper conduct of practice.
That's all he would have had to do.
That's all he would have had to do. And basically he would have turned the complaint upside down.
Swing and a miss.
Right.
250 to 1,000. 116A1B. Because if it went to litigation, you have to be examined. Both parties would be here to talk about what happened. So,
Right. And they're both acknowledging the fact that that existed.
it can be hard to back out of that one. So,
Yeah.
The respondent knew enough of the regulations to know that, hey, this guy is an unlicensed surveyor, or he did it unlicensed, whether he had credentials to handle equipment and do the somebody smart enough to turn that over to us. So, you know,
I mean, as a licensee, he has that responsibility according to these rules to protect the profession.
Yes.
The respondent has a disciplinary history.
I think it's a
So
bad-
they filed the complainants map, not the respondents map. It's the same one.
No, the complainant filed a map and he wasn't a surveyor.
That's what I'm saying.
And the respondent said, hey, look, you're not a surveyor, you can't be doing that. So they got a little sideways, but then apparently they made up with enough that the respondent finished the survey.
Some of the terms could include requirements that the respondent provide the information necessary for the board to investigate the unlicensed conduct and to determine the order. If the agrees to it, to submit that information and given the terms of the penalty, deem that appropriate, but that's, I just know that could be part of the requirement is that give us enough information that we can look into that aspect of your response.
And 94, 2002, 2007. All this is. Doesn't mean you weren't filed. This brings up the fact that a lot of our licensees don't seem to be backwards and forwards familiar with their own law and rules. Now, the Architecture and Engineering Board, they have a test that they've created themselves, law and rule examination. Perhaps we should put together a 50-question or so law and rule examination to attach to these consent orders as part of the discipline. You gotta know this stuff.
Yeah, I mean, I know states that do that. That do that very thing that you're talking about. Surveyors.
You think they have? Are you familiar with what they look like?
Yeah.
Have you seen it? Any chance of obtaining the sample?
I'm trying to think.
Just a template or something?
I'll have to study which one that I saw.
Let's
Anyway, my notion to the board is that we send consent order back to this respondent and along with a civil penalty of $1,000 and request that the respondent provide the plat that is in question so that a board, if the respondent is unwilling, that a board complaint can be filed against this individual for unlicensed practice. That's a throw out thought for the board.
provide proof of that allegation.
Yes.
Why he thinks this was unlicensed practice.
Right. That's in there.
Provide to us what you provided to him. What you're supposed to provide under 0820-0402.
If this individual has had, the respondent has had 4 claims filed against him over the last 15 or so years, I would have really thought that if he waved the flag of the complaint, that he would know the rest of the story. That's what he,
until I heard he had a complaint filed against, I would have said penalty is probably monetary, penalty is probably more than it should be. It's just 500, but he's had other complaints. He ought to know this thing.
that's what it was. Because I was where you were at. I was 500 until he said we had 4. And I was like, whether they're found or unfound.
I second.
What do you think, Mr.
So it's consent order to provide evidence of alleged allegations against complainant for civil penalty of $1,000.
Right.
That's what you're thinking about. The settlement offer will be,
$1,000.
and to provide proof of the allegation you have alleged against them. Why do you think you conducted unlicensed practice? If you're so sure he should. Because you should have under, you're supposed to tell us, so tell us now.
I agree with that. Must have liked it.
Okay, so we'll entertain that as a motion. I guess. Can the chair make that motion in this discussion? Okay, the chair has made that motion. Do we have a second? Okay, we have a second. Do we have any further discussion? None, all those in favor say aye. Aye. Those likewise. Okay, we'll move on now, Rob.
You got two complaints and one is just more information for anything. So, number 2 is 2012-005691. Complaint alleges professional misconduct on the part of the respondent in violation of 6218-116. Specifically, the allegations that the respondent, a licensed surveyor, made inappropriate statements to the complainant. An investigation was requested, which was conducted and a report returned. From that report, the whole situation appears to be a dispute over a fee payment and what services are contracted for. Hence the allegation by the complainant of unfair business practices. And there's nothing in the complaint that even mentions the respondent's preparation of the land survey. And this one is a true blue contract dispute. So I recommend issue a letter of warning, wash it.
Yeah, how do we define that, Rob?
Define
It's
that
in
word.
Black's Law Dictionary. It's an ancient Egyptian.
Is that a letter of warning or a letter of caution?
It's in between.
I understand. I didn't know we had a wash letter.
It's a combination thereof.
Which one do you really recommend, Rob? Go
I
ahead.
trend toward warning. I'll go with the capital one. Maintain professional relationships with the clients at all times.
I would tend to go along with that recommendation this time.
The public still thinks that we somehow can make surveyors do things and go back and fix things or give people their money back. It's just not true. There's other venues for that.
Any other discussion on it? Okay, would you like to make a motion?
So moved.
Have a second? Okay, we have a motion and a second. Any other discussion? All those in favor? Opposed? Okay.
Okay, number 3 is just more like just telling you what's going on. This is 2012-008051. This guy's a problem. This complaint alleges unlicensed conduct on a repeat offender, in violation of 6218-101. The respondent is known to continue to provide surveying services long after the expiration date of December 31st of 03. No attempts to contact this person succeeded, so an investigator was dispatched to personally hand the complaint materials to the respondent's last known address. This is to verify service so that the matter can be referred to the local district attorney's office to obtain criminal prosecution services pursuant to 6218-115. Once a serviceable address is determined, the local DA will be forwarded the file back to court. So really, I'm just asking and letting you know what I intend to do, letting you approve the plan if you agree. We're just going to have the guy arrested. He's not listed. He'd be out of our hands. It's a class.
Yeah, it's fine. As far as I'm concerned,
expired, and he just never renewed it.
Just continue to practice.
Still using the stamp. So, he won't stop.
Let's go with the plan.
So we have motion in that regard, okay? Yes. Second?
Second.
Okay. Further discussion? Not all in favor, say aye.
Aye.
Opposed likewise? Okay.
The last one is two cases together. It's kind of interesting. It's not here. This is the last one. Okay, number 4 is 2012-010-531, 2012-010-551. One person is licensed and one is not, and neither are in Tennessee. So the complaint alleges unlicensed conduct on the part of respondent 1. You might want to take notes. This is the unlicensed guy in Alabama. By using respondent's 2's license, and he's located in Florida, has a Tennessee license. Using the seal, his seal and caps.
He does have the Tennessee license?
Yes, please.
Okay.
And alleges misconduct on the part of respondent 2 for taking part in this venture. You can't do it. An investigation was ordered and a report received by this office detailing the arrangement. The investigation reveals that the two are not employed with each other and that the respondent 2 is never located in respondent 1's offices, and that all reviews were conducted at a distance, in essence Florida. Although the investigation has the unlicensed respondent stating that, quote, approximately 6 land surveys in the state of Tennessee over the last 24 months were prepared under the licensed respondent seal. That's supposed to be closed. The file does not contain any documentation bearing that respondent seal. We don't have any documents, but he said it.
So there's no, you have no plats with the seal on it?
No, but he said it. And that was part of his notarized statement. 2 recommendations. The recommendation for a licensed respondent is a consent order for a civil penalty of $1,000 for unlicensed conduct since we didn't have any plans. In violation of TCA 6218-101. The recommendation for the licensed respondent, a consent order in the amount of $2,000, $1,000 for violating Rule 082004.072 misconduct for furnishing limited services in such a manner as to enable unregistered persons to evade federal, state, and local surveying and planning laws and regulations, requirements, registration requirements.
It's not recreation.
That's roughly TCA Title 62, Chapter 18. And $1,000 for violating Rule 08200409, responsible charge of service while not being employed and present at the office providing land surveying services.
Let me make sure I understand what's going on here, Rob. We have is the individual from Alabama, is he a licensed Alabama surveyor?
Yes.
Okay.
Thank you.
Okay, so we have a licensed surveyor in Alabama coming into Tennessee
Doing
and
surveys.
doing work.
Florida.
Oh, wait a minute.
The guy in Alabama is licensed in Alabama.
Okay, okay. I want to make sure I get that.
He's not licensed.
Okay, okay. So he is a licensed surveyor in Alabama,
But not Tennessee.
but not Tennessee. Okay. Now, the second person is a resident surveyor in Florida that has a Tennessee license.
Correct.
Okay. So I've got the basics right.
Right.
Okay. So apparently the surveyor in Alabama has work in Tennessee
Yes.
and needs to get it stamped. And the guy in Florida, they have some relationship, and he's stamping the guy in Alabama's work. Okay.
Engineering, we call it plan stamping. I think you call it that too.
Okay.
We don't have any plans.
but we do not have any plats.
If we went to litigation, we could probably find some. But all that's in my file is the statements that I had the investigators take. They're notarized. Where he said that
Okay.
this is what they're doing.
Is the complainant the client who is receiving the work? No. I'm just trying to build a structure around this.
So package and not licensed, you can say.
Now, I think what we're seeing here is we have Surveyor A, who's licensed in Alabama, coming into Tennessee doing work, but he can't stamp the work and make it legal. So he calls Surveyor B, who's in Florida, and says, "Hey, look, don't you have a Tennessee license?" "Yeah, I got one." "Look, I've got 6 surveys. Can you stamp these surveys for me, and I'll pay you X amount of dollars," or whatever the arrangement is. I'll sing at your wedding, or whatever it is. Okay? So Surveyor B says, "Yeah, I can do that. I'm licensed in Tennessee, and that'll work for me." That's the way I'm reading this. I don't know what's going on. So Surveyor B stamps the plats. Surveyor A gives the stamped plat to his client, collects the fee, and everybody's happy. But the problem with that is that doesn't conform with the spirit and intent of our rules. For example, I would have less issue with it, and Mr. Northfield, please correct me, if Surveyor B actually came to the site in Tennessee and met with Surveyor A and discussed what needed to happen and so forth. And then when it happened, when the work happened, Surveyor A sent Surveyor B the information, and Surveyor B went through all the information to review it before he put his stamp on the plat, or sent it electronically, or whatever arrangement that they had to Surveyor A. I would have a whole lot less issue with that, because Surveyor B would be taking some responsibility and having a greater knowledge of what he was being involved with. Now, please correct me if I'm saying that wrong.
No, I think that's exactly what it is. I think that Surveyor A has contacted me because, hey, I'm doing this work up here. I'd like to work under your, quote, oversight, unquote, and you stamp this when I get done. Even though it says that there is apparently neither one's employed by the other.
And you have to have a Tennessee licensed surveyor in your office to do Tennessee work.
Yeah.
But our statute does not say that office has to be in Tennessee.
You get a licensed Tennessee surveyor.
But it doesn't say that office has to be in Tennessee.
No, but he doesn't even have.
Yeah, but that, Surveyor A does not have a licensed Tennessee surveyor in his
No,
office.
the guy that he's using is not employed.
Yeah.
Nor has he gone to the site like the chairman said and even looked at it. So it's not really under his responsible charge.
I guess my concern would be too is that since Surveyor respondent number 1 is not employed by respondent number 2, then that says that number 2 really doesn't have direct oversight of this guy. And if he doesn't have direct oversight of what he's doing in Tennessee, even though he may be licensed in Alabama, and he's not his employee, then that's a no-no.
Well, I think that's what I was saying about furnishing limited services in such a way as to enable unregistered persons
Yes.
to evade our registration. That's what our licensees, Floridians, do.
That's right.
That's his sin. That and the fact that, he's not really in responsible charge of these surveys, because we don't know that he actually went and looked at the site and see what.
I like that. If he had showed up on site and said, hey, tell me what you're doing, and the respondent number 1 says, well, this is what I'm doing, this is how I'm going about it, and then the respondent number 2 said, okay, that's the acceptable practice, and move on with that.
Yeah.
But
I'm just gonna say, it's not an uncommon practice, to associate and work with other surveyors that may not be licensed, for example, in one state. Okay, that's not an uncommon practice. But clearly, number one, you need an arrangement.
Contract.
Yeah, some type of contractual arrangement with them. Number two, if that's the state that you are licensed in, and you're the one that's going to be doing the certification and so forth, then you need to be very familiar with the survey. Because here's probably the best example that I can give for surveyor B. Okay, let's assume that one of these 6 surveys goes to litigation, and there's a real issue and it goes to court. Okay, now surveyor B, who resides in Florida and only stamped this map, has to come to Nashville to testify in a boundary dispute on this particular survey that surveyor A did from Alabama. Well, surveyor B is not going to be a very good witness, because surveyor B, have you ever been to the site? No. Surveyor B, did you review the deeds and all the background? No. You know, you ain't very good. Well, you need to talk to surveyor A over here because he did all the work. Well, are you licensed in Tennessee? We can't hear your testimony. You know, so you know, to me, that one factor.
or you're an unlicensed
Yeah.
surveyor.
Right. That one factor for an individual associating and stamping someone else's work, to me says you better be paying attention if you get involved in this situation. Because if you do go to court, your client is going to get hammered, and if they get hammered, they're going to hammer you.
Would you want to consider requiring an 8-hour first correspondent signing if he's sealed to apply?
If a contract had been involved, then I would say everything is like it should have been ethically, but he didn't. There was apparently no contract, other than may have been verbal. But I just.
It sounds like an ethics issue. Me, I'm just listening to your conversation, it sounds like an ethics thing.
Well, it actually goes beyond ethics. I mean, ethics is, I think that's the threshold. The ethical part of it is the threshold, but the performance part is, in my mind, where it goes beyond the ethics. In other words, it almost says, well, you know, I'll probably get by if this, nobody finds out, you know, that I did this.
Can't contract to do something illegal either.
Right.
That's not enforcing the contract. The contract would have to be, you agree to come to the site and perform X services. I don't think that's what we're doing, and that's probably what it is in the contract. Because the court would look at it and say, you can't do this.
Like I say, I would just use the court example, because that's where this guy's really going to get caught. You know, and because of that, you know, I think it's incumbent that we do something because of that.
You have an Alabama,
No, but I know the executive director of Alabama very well, and several of the board members. They would be very, very unhappy with this.
Alabama Survey Police would not put down.
I think Gavin met Miss Regina there.
Yes.
will they fall on him like an old man?
Perhaps so.
Well, one of your disciplines could be, you know, you could report him to his board.
Well, under our arrangement, this is very important. Under our arrangement with NCAAS, any action that we take relative to consent orders, whether it be penalty, suspension, or revocation, particularly those 3 criteria, we are supposed to send to NCAAS that individual's name for the sole purpose that they can notify other boards if that individual is licensed in other states. and then the other boards can review what we have done and see if there's any action that they need to take relative to that licensing in their state. That's one of the premises. That's probably new for you, Nicole, but that's one of the premises around NCWS. You know, they not only help us with our exams, help us with multi-state licensed applicants sending us information, but that's part of what we're supposed to do is to notify them. And in the same token, if somebody, for example, if I'm licensed in Kentucky, if I had a civil penalty against me in Kentucky, they're supposed to send it to you all, to Donna, so that she would know that, hey, look, one of your registrants has had a civil penalty or a suspension or whatever in Kentucky.
How is that reported? How is that?
But for NCWS, I think they submit a monthly report or something.
Yeah.
Because the A&E board does that.
Yeah.
We take reciprocal.
Right.
Let me ask this one question.
It can be a career injury
Yeah.
because it causes a domino.
I really don't think it really needs to be even the NCWS. I think that if that registrant in Alabama is practicing in Tennessee without a license, I think that this board has a responsibility to report that to that board.
I agree with that.
Not just the NCWS.
I'm just saying there is a mechanism out there for this, but I agree with you 100%.
We should probably wait until after the discipline is completed, though. Once we have a concrete finding.
Yes.
Oh,
discipline.
yes.
Yes, I
It
understand.
has to be completed
Right.
before they're notified.
Right now,
Because
it's just a suspension.
right now, we're just talking in general as far as the logistics of if something happens, probably what should be done. I agree 100% with Galen that I think we should notify whether NCWS does also or not. Because that's part of what NCWS is trying to do, Nicole, is they're trying to bring engineering and surveying boards to where it's a very clear, uniform communication between all the licensing boards that are members.
I understand. I have to do the same thing for some more technical appraisers. We have federal requirements, so
Okay.
we have a federal agency, we have to report these to other states, you know, we do this with their people. And it's, you can look up on the National Registry to see every state we've ever been disciplined and they ever have.
NCWS is quasi-governmental.
Right.
Yeah.
I understand more of an informal process.
Right,
than
yeah,
it is.
right.
It's more of a contract arrangement, I mean, law.
When I'm looking at these recommendations, then, I think these recommendations probably are valid. Maybe we ought to just take them as is. I make a motion that we handle each one of these recommendations.
But now, Nicole, I'm going to jump to the second one, Gail. Nicole mentioned the possibility of a ethics course
Oh,
for
wait.
Florida survey.
Okay, I'm sorry.
That may be in addition.
Well, I don't know if that's appropriate, no, that's why I just.
I definitely feel like it's appropriate.
I think it is appropriate, and I'm
Yeah.
sorry, I will amend that
Yeah.
motion to include the ethics course.
For the second respondent, or both of them?
No,
I think
we just
At
have
least the
jurisdiction over the license.
right.
Well, the fact that we know that respondent one is licensed in Alabama, that's sort of additional knowledge for us. But the fact that what he did in Tennessee was unlicensed practice, so because it was unlicensed, and correct me if I'm wrong, Rob, we are somewhat limited as to what we can do. Probably the $1,000 is probably about all we can do
Yeah, for unlicensed.
to respondent one. But now respondent two falls under basically our full discipline. He's ours. Yeah, he's ours.
I'm right there with you.
Okay. Well, I tell you what, let's do, if it's the board's pleasure, let's vote on these two items separately, if we
okay.
can, if that's all right. So I'll entertain a motion for the consent order for respondent number one first.
All right, so moved.
Okay, we have a motion to accept what has been prepared in our legal report. Do we have a second?
I second.
Okay, we have a second. Any further discussion? All those in favor say aye.
Aye.
Those likewise. Okay. Okay, so we've approved the respondent one. Now, respondent number two, do we need to have any further discussion about that in any way? Satisfied with our penalty and adding the ethics course? Yes, okay.
I'll make that motion.
How much?
8 hours.
What time frame?
Like Sue, I think 3 months. Sue said 3 months, that's what we're gonna go with. We're sticking to it.
I think 90 days is
Yeah.
sufficient time.
Yeah, I think there's enough stuff out there you can get hold of.
Send your payment in and get busy with this ethics course.
I just like
Yeah.
to tie the neat little corners, because if they don't do something, then what? So we have an action. And then what?
Okay. Do we have a motion on the floor to accept what's written along with the addition of an 8 hours ethics course which must be completed and applied to in 3 months? Do we have a second?
Second.
Okay, with a motion and a second, any further discussion? Not all those in favor?
Aye.
Opposed, likewise.
All right, Mr. Chairman, that's it for cases.
Okay, that
Put us in
concludes our
good
legal
stead.
report, and I think we're gonna take about a 5 or 10 minute break right here, Miss Donna, if we may.
You want to turn in your iPads, it's just past the legal report.
Okay, it's now 10:52, and we will resume our meeting. The next item on our agenda is a gentleman to speak to us about a denied PLSIT application. I see the gentleman is not here. His scheduled appointment was 10 a.m.
Right.
Have you had any notice from him, Donna?
No, I haven't. I sent him a letter by email on Wednesday, on today, telling him when his, his appointment time, weather, and all that stuff. And I have not had any other contact with him. He's not called, he's not sent emails, So I reckon, and he's not here today, so I recommend that we uphold the previous denial.
Do you feel like we need to have a motion for that? I mean, we're not changing anything any different. I would think that we need to, but we will if necessary.
See petition for,
Yeah, I think we should just,
Okay.
for safety's sake, anyway.
just to show you address.
Yeah.
Okay, the board will now accept a motion to withhold the review of Mr. Robert Rousey's application as we did in August, to maintain the same opinion that we had at that time.
So we're
Seeing he's not present.
Second.
We have a motion and a second. Any further discussion? Call for question. All in favor, say aye.
Aye.
Opposed likewise? Okay. Don, if you'll just simply notify the gentleman and let him know that the board maintains their posture of what we did in August, specifically due to the fact that he did not attend to address the issue. Okay. Well, let's just continue. Rob said he's going to be with us a while, so we'll just continue. We'll now go to new business. First item on the agenda for new business is the director's report.
Okay, it's the same thing. We're still having the actual shortages, although we do have a temporary covenants right now. And Cole is working with Human Resources next door to get us some permanent help. And the laws are, and for the FS exam and fees are 2011-12, as of June 2012, we have an adjusted balance, including our balance from previous fiscal year's revenue or deficit, $296,300 for eight, is that an eight?
It's an eight.
Okay. $844,000 and 81 cents. Budget information fiscal year 2012-13 as of August, year to date as of August 2012. We don't have an adjusted balance yet. Our total revenue is $13,989. Disciplinary action revenue information, FY 2012-2013 year to date as of August 12 is $4,279.37. 31% of our total revenue for the year to date. We have 25 open complaints, 16 have been on time, so that's 64% of on time complaints. We have a total of 1,279 surveyors, 821 active in-state, 67 in training. We have 36 inactive, 28 retired, and 327 active out of state. That's about it.
Okay, is there any questions or discussion relative to the director's report? Okay. All righty. I notice on our iPad here that we have a couple of questions. Now, I guess that's where we're at on our next item. Our next item says discuss request for board opinion regarding types of surveys. So I guess that's where we're at on our iPad. The first question comes from, I assume this is our friend Mr. Keel. The same one we've been familiar with for several years.
No, this is not.
Oh, this is another Mr. Keel?
Yeah.
Okay. We had one that we were quite familiar with for a while. He was a regular customer, you remember him, sir?
This is the complete, question, asking if there was somebody's That's his original email. Yeah, that's it.
Okay, well, let's take just a minute and let the members read this sequence of emails here that you've just handed us, Don.
Okay.
And we can try to discuss it. kind of read this, digest what's going on here. It seems as though the civil engineer owns a piece of property next to a cemetery.
Well, there's a cemetery on his property.
Or it's on his property. It's either adjacent or on or both. And it seems that he has made some efforts to survey his property himself, but he has also had somebody else survey it as well. And I guess whoever the company is stating, it says this person states the property lines are correct. So the question posed to us is twofold. Question one, is it legal for a person with a civil engineering degree from a college in Tennessee who is not a certified surveyor in the state of Tennessee to survey his own property in Tennessee? That's the first question we need to answer.
That was the question he asked initially, to which I wondered, well, that's not going to be enough information for you. Because if we'll probably ask questions, what's the purpose? Will it be recorded? Survey like we think of it, no, it needs to be a survey.
Well, our primary charge is to protect the public. And I would think that if an individual chooses to obtain equipment, or whatever may be necessary to survey their own property for their own personal use, I personally don't see a lot of harm in that. Where the harm comes in is where they produce a map, where they have a deed crafted from that information. However, when I say what I said previously, it should be also duly noted that an individual technically is not strictly surveying their own property, because if this piece of paper was a piece of property and the edges around it, you own what's inside of it, there is other entities that own adjoining you, therefore you're technically surveying someone else's property line while you're attempting to survey your own property line. So my response to his first question would be no.
Even if you subdivided your own land, give it to your kids or something, what if one of those kids decides to sell it to somebody else? Depends on what, it's not just what you're doing now, what's going to happen later.
Well, in my mind, the minute a deed is made, then it's unlicensed practice.
When you draw a deed to transfer title,
That's right.
then the unlicensed takes effect. He has done something that the survey is not licensed.
That's what it looked like.
Do what?
That's what it looked like to me.
I mean, I think that would take over, even though he's a licensed engineer.
That's not the right
He's not a
license.
surveyor. And once he decides that he can survey and he divides his property, he gets ready to transfer title, then he's practicing surveying without a license.
Again, from the standpoint of any time that you attempt to do surveying, you're affecting someone else.
He needs to talk to that guy in the
An hour
bar.
in the future.
Yeah. You're called out of work. But like I say, in as much as he wants to lay out his house on his property and all this kind of stuff, he can do things of that nature, But as far as the boundaries of his property, which falls within the definition, he is in effect surveying someone else's boundary, even though it's his property. that line is in coincidence with someone else, and it may be multiple parties. It could be several owners if it's a very long line or whatever, so he ultimately is affecting someone else.
What if you took that rectangle in your hand, cut it into 4 squares without affecting the outside boundaries? So this is for my 4 children, and established boundaries.
As Galen said, if the deed is written, or if he put in 4 postage stamps inside this piece of paper right here, once a document is crafted from that work product, in my mind, it's unlicensed survey.
Even if you say it's my land, I can do what I want to with it. It's, well, that might be true now, but in the future, when it does go to somebody else, you're affecting somebody else's right. You can't say it will be mine forever and ever because you don't live there. Like now they can survey. If you're a surveyor.
Like I say, idealistically, you should be able to per se survey your property, but where you can't survey your property and be unlicensed is because it adjoins someone else. So you're affecting someone else in the public, their rights to the property lines. And you're creating a line or whatever, even though another surveying company's sort of checked it or whatever, you're establishing a line that may affect others. And that's where I'm at. So my response to both of these questions would be no. Would be my response. I don't know what to
No, I agree. I just don't think that, they can survey their own property. I want to go out and survey my property. They have one survey his property. Live survey, but when it comes to doing something beyond that, final is transferred, land or sell it, doesn't matter where it is, then no, you can't do it for the purpose of planning to sell or whatever you want to do.
Well, a very simple issue would be if I survey my own property and I'm not licensed, and I put stakes along this line right here, and I build a fence, and I've got 2 adjoiners beside me, and that line does not coincide with their line. That's surveyors for you, determine where that property is, based on the writings. The unlicensed individual does not have the training and atypical knowledge that it takes to do what is necessary to render an opinion where that property line is based on the writings.
But if you wanted to find the 4 corners of your property so you can build a barn in the lower corner, just to make sure it's within your property, you could probably do that.
Probably.
Just to have,
As long as you're not transferring title.
just to make sure you're not building it on.
Yeah, when you start affecting someone else's rights, and I think transfer of title affects someone else's rights.
Absolutely.
Yes.
Let's say the example you gave, Tim, if he wanted to put a fence up, he found a corner on the northeast corner, the southeast corner, and he was capable of calculating to put his fence in, fine. But I think that, you run the risk of, you want to go to court. The guy next door to you, he said, well, my line doesn't agree with your line, then get a surveyor out and either verify or disqualify what you have done. I think both of them are really going to be held up. Whatever survey he would do would not hold up to court.
No, clearly, sir.
One of them was sent a letter out in the next week. Question, Mr. Keel. You don't need to know this, I know Mr. Keel. My response, I should make sure the answer is all right. We had another question, so I'll cover this. unethical and or illegal to pay a third party for a project that ultimately the surveyor does for profit. For example, if prospective client A contacts company X out of state non-surveying terms without a surveyor employed there for prospective surveying work, providing name, address, scope, and contact information, company X sells this information to surveyor B for a fee. Surveyor B then must contact client A to confirm time, scope, cost of service bill directed to client A. If the above, for example, is the above, for example, either unethical or illegal or both, if so, which TCA or rules pertain to this?
Under section 0820-4-.06, is acceptance of work under the rules of professional conduct. It states, paragraph 1, it says, the registrant shall not offer or make payment for consideration either directly or indirectly by way of commission, political contribution, gift, or other means in order to secure work.
Reference that again, I wasn't quick enough.
0820-4-.06, acceptance of work under the rules of professional conduct. The way I read the example, a non-surveying company is soliciting work, and in order for the surveyor to do the work, he has to pay the fee. And I think that would fall under that particular.
I think so too.
I really need to do a better, but I did follow one more time. Sorry.
Okay, rules of professional conduct, which is chapter 0820-4. Then under the subsection, acceptance of work, which is 0820-4-.06, paragraph 1 states the reason why that this is not appropriate. And if you just simplify it, just says the resident shall not make payment of any consideration in order to secure work. If you just simplify it, just a very few words without all the rest of the text.
That makes it simple. Appreciate that clarification.
So it's both.
Which, in strictest sense, that falls into what we see with, technically we see with U.S. Surveyor and all these other companies. Except in different from this example. This example is that they're actually selling this project to the surveyor in this example. In other words, I'm from New Jersey and I call Gail and I say, look, if you give me $500, I'll give you this lead contact information on this job across the street.
The same fashion, we'll have staff communicate a response to this. In late September, the Administrative Office for the Board of Examiners for Land Surveyors received a letter from the attorney requesting a formal opinion from the board. This item was added to the October meeting agenda by Ms. Wilner. Upon additional review of this letter, it's been determined that additional information from the requesting attorney will be gathered before board can give an accurate response to this request for information based on all relevant information. Following this meeting, Mr. Herman will be communicating a letter to the requesting attorney to request additional information. So no actions needed on that one. I just didn't want to have it not be clear that we didn't cover it. It wasn't listed on the agenda. I just want to make sure that at this time no actions needed from the board. Dispose of and shred that item.
Okay.
Not relevant at this time.
Consider it not relevant, just move it up.
Thank you.
Okay, next item on the agenda is discuss the NCAAS annual meeting. I think I'll turn that over to Mr. Northcutt. His first one, and
That kind of blends in with discussion of conversion to CBT.
yeah,
Cover both of those.
yeah, we'll talk about both of them. Yeah, if you want to give us just sort of a thumbnail report, maybe, as best you can.
I'm really not sure where to start. But I'll say this, the first thing is most interesting. Probably the most informative 3-4 days that I have ever attended any kind of seminar or what have you, dealing with all that we deal with here in this city. The examinations, the security of the examinations, the formulation of the examinations, giving of the exams and the grading of the exams. I was really kind of floored with everything that went on with that. It was an eye-opener, and I understand. I think you're on one of the committees. I didn't volunteer to get on the committee. I didn't know enough to volunteer to get on one. And but I attended a couple of things dealing with the security of the exams and the formulation. And I know we have. I think we have the applicant that wants to take an exam and needs special provisions. And in the process of this, and I think the very last seminar I attended for a while back in Nashville, one of the things that they came up with was how people cheat on these exams. And a dyslexic individual said, I need to be in a place where I can read the question aloud and go through everything and read the answer like that. They gave this individual that opportunity, and they had a recorder in their fanny pack, and so he read the entire exam and all of the possible answers were on the recording. So I know we have one that's coming in for special provisions in this exam here, and I thought, oh, wait, we might need to. I think he's licensed in another state, but I just think we need to just be very careful when we start dealing with the security of something like that. The other thing was the young lady in the exam had a camera in her sleeve of her blouse, and so she'd take the exam, scan a page, record it, and she'd go on and answer the question. She'd turn to the next page, scan that page, and do the same thing. The proctor in the exam saw this action 3 or 4 times, became suspicious as to each one of these things, and they called her out. They found the recording devices. So I thought, people are ingenious in the things that they do, but NCAAS has seen it all. Maybe not all, but they've seen 99% of it. But as far as the states working together, working with NCAAS, the model law, and what have you, I was very favorably impressed dedicated the folks are, the board members that are on that committee are in doing that. Of course, some of the things that went on that were laughable, and I thought, well, okay. So we see why we don't go to certain places for some of these annual meetings. But anyway, it was most interesting, and I'm grateful about that opportunity to go up there. And I look forward to the next one, so now I know a little bit about what's going on, and probably learn a little bit more rather than sit there and be awestruck with everything that's going on.
I'm glad Dave Helen got to go. I've been to several now, and I'll just reinforce what he said. It's so very important to remember this board. I know I've got to tell you on your years group, but there's just so much that goes on. There's so much that goes on. And when we break out in our zone meetings and so forth, and we do the zone meetings, we have a very good interaction and relationship that we build with all the other boards in the southeastern United States. That's just really positive, because when you get right down to it, the things that we're doing are the things that they're doing. So everybody kind of acts alike, functions alike, and has the same type of agendas for all of them. As Galen said, this stuff on the examinations is unbelievable. I mean, NCWS maintains like a $6 million exam breach escrow just for this type of, I mean, it's unbelievable. Their security system, and then the fact that they have all these additional questions, and the way they set the exams up, and CBT, when they get to I mean, it's even more sophisticated, because it's what they call linear on-the-fly system, and based on how you begin answering the questions, dictates how the next questions come to you, and so forth. I mean, it's absolutely amazing. So I think it's critical that our board maintain going to these two meetings that we go to, the national annual meeting and also the zone meeting, just to stay up to speed with all this, because it is changing so much. As quickly as the FS goes online, 2014 for the CBT scenario, right behind it, the PS will also be going online. So 14 hours of our examination will be going online, and we have some work to do for those things to get those up to speed, so that our rules and statutes will flow with that type of examination as our applicants get there. I've got a little article that we'll discuss on that here in just a minute about things that we need to consider for CBT. But it's so very important that we continue to maintain this relationship. And I hope that at some point in time, the state of Tennessee will again allow this board and the other boards to accept the NCWS paying portions of the board's government. That's something that's decided with legislation because it's, we pay a large dues to NCWS, and that's part of what those dues are for, to be able to give them recruits through those. As far as the committee that Galen spoke about that I'm on, it's called the Examination for Professional Surveyors. Everything in NCWS is acronym. It's known as EPS. You have to have a cheat sheet of about 5 pages just to keep up with the acronyms.
The National Manual did have a couple of pages of acronyms.
Once you kind of get the hang of them, you sort of begin to know what they're talking about. But it takes a while. It's kind of awestruck when they start throwing all the acronyms out there.
Sean called me, bewildering.
Right. But I had my first meeting with that in November the 16th in Phoenix, Arizona. So send me out there for me. And the topic of discussion that I have a charge to work on is, should experience be required after an applicant passes the FS examination? folks that will be taking the FS exam this Saturday in Murfreesboro, when they get the results and they have passed, which will be, say, January, the scenario with NCWS is, should they now have, let's just say 2 years experience, once they pass the examination, before they actually get their certificate. That's the charge that I'm working on. And then at that point in time, once they receive their certificate, then whatever the next experience that the applicable state has will then kick in. So that's one thing that they're seeing is because many more states have a BS degree requirement for surveying, and the students are being allowed to take the examination in their final semester as a graduating senior, they're seeing that there's a shortfall in experience to getting to the licensure step. So that's one reason why they're wanting to do that. So that's just one task. I think our particular committee has like what they call 7 charges. There's about 12 of us on the committee, so 2 or 3 of us will work on different charges. I'm sure I'll probably end up with another one by the time it's said and done. And then there's multiple committees, and one committee will do a report on it, and it'll go to maybe 2 other committees in order to interact with how everything works. And then when it gets to the back to the national meeting next August, which I believe was in
San Antonio.
I think it was San Antonio. When it gets back to there, it'll actually be presented to the members from all over, all the boards, and then they will actually vote on it to begin to move it into becoming part of the structure of NCWS. So it's a pretty complex thing, but as Galen said, there's some of the folks that are there that are so intelligent. It's just absolutely incredible how smart some of these. I mean, these folks are PhDs. You know, I just sit in awe of a lot of them folks. They really are. And there's some good old plain folks too. But everybody really works together with the common cause. That's the thing that I see. Whether it's the member board administrators or the legal side of it, surveyor or engineer side, it's all common goal for the good to make the professions better.
Our Southern Zone meeting is in Biloxi in April. So I guess the board needs to decide who will attend the April Southern Zone meeting and the August national in San Antonio. I don't think it's real hard to figure out, but we still want to discuss it.
Discussion is, I really think we all ought to go to that.
All both of
On both of us.
especially during this critical year, because the next year is when CBT is implemented.
In April the 14th, which is, it sounds like a long time away.
It's not.
It's really a little over a year. So, anyway, but that's pretty much the report on the St. Louis City. Good trip, very informative as always. A lot of things happen. A lot of different one of the biggest political footballs that they had on the convention floor was engineer surveys. Yeah, they're all about that. Trying to.
You'll talk about that in your surveyor forum? Because I was in the leader forum, I think, at that time.
Yeah, they're really trying hard to get that eliminated from engineers model law. I think it'd be good. Look at the surveyor comment.
And it gives us a chance to participate in voting on model law applications.
Right.
You know, there again, of course, I understood part of the reason for the engineer doing both his survey, dealing with, he had to deal with leveling and elevation and stuff he needed to do. Okay, I understand him doing that, but it never came around to, there again, transfer of time of property. You know, he's qualified to do the work that he needs to do for his something else, I don't care what it is, as long as it's not land surveying, then I don't think any of us have it. And I forgot which state it was, Utah or whoever it was, or maybe it was Vermont, somebody, one of those northeastern states. They really had an issue with that. Apparently, so that's a real problem.
Rhode Island.
Yeah, Rhode Island, that's right. That's a real problem with engineers doing surveying. And doing it, I think, including transfer of title.
Well, many states have already, I know North Carolina has, I'm not too sure Virginia have already addressed easements where survey is. And I think that's right, because a lot of engineering firms are doing it. Okay, thank you, Katie. On the CBT, I don't know if you all got your newsletter from NCWS, the little licensure book that comes. I got mine this week. Okay. There's, over the next year, NCWS is basically asking each member board to kind of begin to discuss and formulate some sense of direction for how we're going to deal with CBT. Because CBT is basically going to be a scenario where an applicant can test within a 2-month window, and then there's a month off, and they can test again within but this board is going to be very involved in that process, as we always have, from the standpoint of we still got to approve applicants. They have to go through us before they can go to the testing center and through NCWS and have to take the examination. They have 3 options here. I'm going to just read these in this letter, this article that we sent. Let's see, it says option 1, examinees apply to NCWS directly and do not choose a board, and they attest that information submitted to the registration system is accurate and complete at which point they are marked approved automatically. They take the exam and the results reported directly to the examinees automatically. Examinees may or may not apply to a board of their choosing at that time for an engineer or a survey certification, because CBT also is for engineers too, so they speak to both those things. If they do, the board logs in the NCWS examinees management system and verifies the exam results. This opinion is best for boards who wish only to process the FEFS examinees once they pass the exam and wish to pursue certification or licensure in their state. That's an option. Second option is once examinees attest to a board's requirements in the examining management system, they are marked approved automatically for a defined number of attempts as identified by the board, after which they must be approved by the board for each additional attempt. Results are reported to the board. This opinion is best for boards that simply want examinees to attest to the requirements, but the examinees have to perform some action after a board-defined number of attempts. That's another issue, is how many times can you take? Option 3 says, once approved by a board, examinees have a defined number of attempts as identified by the board, after which they must be approved by the board for each additional attempt. Results are reported to the board. This option is best for boards that wish to continue approving their examinees manually. I kind of see that we just want to put closer to number 3 initially, but we may get somewhere else. Basically what they're saying in these things is if the board yields to NCWS to allow an applicant to apply to take the examination, then the applicant in option 1 there is not required to submit anything to any board, period. until they decide that now, you know, I've got my LSIT and now I want to go get my license. Well, I have a concern with that because then that's somebody we don't really know nothing about and went out here and got approved by another approving authority and may or may not meet our statute. The only difference in option 2 is that there's a specified number of attempts. Option 3 is more similar to what we're used to, where we approve an application. But the difference there, because it's a computer exam, is that we're going to say that Johnny or Susie can only take the exam X number of times before they come back. Because the scenario here, and this is what you got to wrap your arm around. In CBT, an applicant will be able to take a test on Monday morning. They will have their results probably before the next Monday morning. If it's a 2-month window, that means there's 8 weeks in a 2-month window of potential examination. They can take this examination anywhere. For example, if you lived in Clarksville, Tennessee, you could drive to Bowling Green, Kentucky to take the examination. Okay? We would still be notified by NCWS that that person was approved. We would approve them, and then we'd still be notified that John Q. Public is taking the LSIT. They passed it or not, or whatever. We'd still get the notification. The situation comes up of how we're going to need to handle this is, as far as the exam goes, do we set the number of times that an examinee can take it within a window or within a year? That's what this board is going to have to wrap their arms around. In other words, if we approved, let's say we approved applications today, CBT was invoked, people were notified, and starting January 1, they can start taking CBT for the LSIT exam. We've got to be able to tell them, look, you can only take it X number of times. If you don't pass it X number of times, then you've got to reapply to this board. The other side of this issue that's convoluted is currently, correct me, I'll please, the LSIT, there's a $25 application fee, and then there's a $25 exam fee. Now, that exam fee is going to leave us, okay? Once we approve the application, the exam fee will be paid at the site or before the NCWS. We will not see the exam fee. Okay? And that ultimately is going to happen with the PS exam also, income received, which obviously, as you all can read between the lines, that affects our contract with our examiner. Okay, also because these things are now being taken out of this brand new 5-year contract we just signed. But we had to do it that way. So there's a whole lot of stuff involved right here that we've got to look at in order for us to, we may need to, for example, we may need to adjust our application fee in order to manage these other things. Because part of the revenue, I know I'm jumping around here, but part of the revenue of this board comes from the examinations. And, for example, I know that NCWS charges for the examination booklet, they charge for the examination and the scoring, right? Okay, so there's a fee there. For example, if John Doe pays $125, I don't know exactly what the fee is, John may know closer, but we pay X number of dollars back to the NCWS out of that $125. Is that correct?
No, I can't remember exactly what the exam fee that they charge.
And then we have, because it's still paper and pencil, then we have a fee that's associated with Peter Messier, who actually proctors that exam, doesn't write that exam, he proctors that exam. Along with getting the room and all that kind of stuff. Like I say, this whole scenario is getting ready to change, and we've got to be ahead of the curve so that when the change is made, we've done what we need. So that's why I'm kind of throwing all this out in the manner I'm throwing it out. We've got to be able to wrap our arms around a whole lot of things. We can't just arbitrarily drop off an exam fee, not paying any attention to how it affects everybody else. Because we still got to keep everything intertwined. If that makes any sense. So I think for this meeting, I think that that's kind of where I'd like to kind of leave it with all of y'all, so we can think about this a little bit more. Because we're going to have to kind of decide, you know, what's the frequency we're going to let them take the exam, you know, are we going to let them fail it 10 times a year before they come back? I mean, what are we going to do? Other member boards are working with the same issue. They've not drawn a line in the sand.
I think we should probably say so many times within 4 months, 6 months, or a year. It doesn't matter how many times you take it. You can only take it so many times within a year. If you take them all 6, you can take it 6 times in a year, and you can take them all at the beginning of the year, but that's it for the year. Because the frequency can shift on us. The year's not going to change, so I think we should use a time frame that's not going to change. And we say you can take it 4 times in a year, or you have to reapply.
It's very easy to set up a state contract, that way testing centers, they can learn a contract and they can have exam proctor like PSI, Promisor.
Well, see, we don't have to do that, Nicole, because NCAAS already has Pearson View on board, and they're actually going to, they actually take care of that. They actually, Pearson View lists the sites for your first aid. They handle all the testing. NCAAS provides the exam and they grade the exam. All that's clean out of our hands. We don't have to worry about any of that. The only thing we would have to worry about would be if this board decided, and this is another direction that probably we're going to go towards, decided to make our TS exam a CBT exam, which is our last 2 hours of the exam. So that's, some states have it, very few right now, but that's a direction that they're looking for us to go to. So these are just some of the logistics that I want to throw out and get everybody thinking, because we really need to begin in our February meeting firming these things up.
How many times a year do they take it now?
Well, what I was going to say was they're only taking it twice a year right now, and we're only letting them take it 4 times in a 2-year window. Is that correct, Don?
And now it's going to be virtually year-round testing. It's just how many times we can allow them to take it.
Well, the halt to that is when we decide to review applications. Because I certainly don't think that the department would be very happy with us making monthly just so we can review 5 applications. Yeah. And I personally don't intend to do that. You know, I think that we can review applications probably reasonably asimilar to what we do now. And not change things too often.
I have a question in regards to the NCAAS. So far as reciprocity, you mentioned a scenario where somebody goes to another state and takes a test. Are they asking the states to figure out one system plan and everyone has the same plan? Or can each state set up its own requirements for whether or not they have to do, get the board approval before they go take the test, and then Kentucky they would choose not to get board approval, just completely up. Can everyone choose different options?
Yes.
Everyone need to get on the same
Yes,
option?
I think that's in the spirit and intent of this particular memo that they put out in the licensure magazine, is that each state will make their own decision as to how they want to handle that. Now, as far as going back to your initial statement about being able to take the test wherever, it's NCAAS's opinion and view that because it is their exam, and it is a national exam, no matter where it's taken, if it's passed, it's passed, as far as the FS exam.
At the last engineers meeting, a representative from NCAAS showed up and showed a map of the U.S. They probably did it at the national meeting too at some point. It showed all the Pearson new places that you could take it all over the United States. You could go to California and take it. Here's my score.
Right.
It doesn't matter where you took it.
Right.
So an applicant who resides in Tennessee, you could establish a requirement that they apply first, then.
Correct.
But if somebody, say, lives in Kentucky or Illinois or something, and they took the test there and applied to Tennessee, under your reciprocity agreement, would you accept it, the fact that they did it out of order, or?
Yes, we would accept, because it's a national examination, the FS and the PS, even though the FS would be CBT and the PS would be paper at that point in time, probably, we accept those results. The difference in your example would be the experience requirements that our board would have in order to allow an individual to sit for the licensure exam.
I'm just, it's a learning opportunity for me, so I want to.
Well, the other side of that is that we will have to also address the approval for the PS, because the PS is structured around experience within our current statute. So in other words, an individual would not be able to take the PS exam to go to use your state in Illinois for us without our approval. Yes. That's correct. That's correct. Well, like I say, this all sounds real complicated because it just involves a whole lot of things. It involves some statute change, it involves some structure change for us, and we just have to be able to be mindful of all the components that are part of it, so that when we address one thing, we don't miss something else that is part of it. Now, our engineers board is having the same growing pains for the very same issue that we are right now.
Are the professional organizations getting behind legislative change? Because sometimes pushing legislation through regulatory authority, can be difficult with that.
To be quite honest with you, I don't feel like I'm going to say it this way, Galen, correct me. I don't think that TAPS has any real knowledge or opinion, either one, of what we're discussing here today.
Well, it's just important that, the legislators, I'm an outsider, it's confusing to me, and I'm sure the legislators are on the same, learning curve to understand why the legislation is important. If you need legislative changes, it's helpful to have professional organizations and
Well, see, that's why it's critical.
yourself explain it to them.
That's why it's equally critical for us to, because of the way our statute is structured about what fees we can charge for certain things, and it has to be approved through the legislature. That's why it's critical for us to analyze what we charge today and what we have to pay out of what we charge, and basically what our margin is for the monies and finances for the board. Because the last thing that I would want to be on board doing would be basically just leaving that alone and not doing anything to it, and then the board suffer financially because of all this national change. Because then that puts us in a situation where, because if we didn't pay attention at the time we should have paid attention, it puts us in a situation of penalizing all the registrants at a later date, and I don't want to do that.
I understand. I'm completely, I'm going through a similar experience with another thing. I have to, in 2 years, I have to make sure that the statute for appraisers changes to require fingerprint background check. That isn't a national requirement, but getting through legislation is timely. It takes a lot of time.
Right. And as you well know, anything to do with dollars
Anything to do with dollars,
is really
it
tough
charges
through
your
legislation.
licensees, whether it's directly or indirectly, the legislators are going to be very concerned.
You know, as long as it doesn't have a financial impact on who you're legislating for, you got a better chance. If there's a financial impact at all, then you know that's another issue. That's a red flag.
Yep. So, you know, be mindful not only that this office needs to change, but we've got to communicate effectively with the legislators on this one to make sure that your testing changes take place.
Edit our statutory wish list. Remove references to an 8-hour written exam. Anything that indicates something that wouldn't allow a computer-based test. Trying to anticipate that.
Right, and because our surveyors and engineers, architects statutes are very, very similar, and it's a good thing that we have a common attorney for both boards, and that makes it easier for us to be able to try to take something through the legislature because it speaks to a much larger, we're 1,148 surveyors, they're 20,000 engineers and the architects, so numbers do speak. They do speak, and if it's clear for them and we can ride their coattails if we have to get through legislature, that's fine.
That's what
And I just make sure that Ms. Mulder notifies you all, so whenever it comes up for legislation, you have the opportunity to be there.
The thing I'd like to request, Dawn, for you to do between now and our February meeting is try to put together a few numbers for us that shows the board, we charge this, and this through the examination process, or how it's taken. And out of these charges, we have, X amount of dollars that we have to send to NCAAS for the exam. Right now, it's an exam booklet and it's grading of the exam and so forth. So if we can do that, we can't do nothing with what Peter does, but the FS and PS exams are tied directly to NCAAS, and that's 14 of our 16 hours. And if we can look at those fees, it may be that, as those roll into CBT, then we upgrade maybe our initial application fee or whatever, and we end up basically with the same revenue stream, even though it's handled through the And that's what I'm concerned about. I want to make sure that, we at least stay right.
we and the engineers need to closely monitor NCAAS is due. So we really need to be there in the spring, most definitely in August.
Right.
And see how this is unfolding.
August is when the hammer's going to go down. Everything's going to be put in full motion now. It's already set up. They've got the database with questions already done. And they're testing. They've got testing centers where they're practicing right now to see how it's all going to work and everything. So
Those meetings are how we're able to see what the testing centers look like and how they're implemented. Because the people that give the test have representatives at those meetings, so that we're able to see what they're doing and how they do it.
yeah, it's so complex that, for example, on the engineering side of things, they have member board representatives go and they give tests to Saudi Arabia, and Turkey, Japan. It's amazing. When you start seeing where they're giving these same tests, they're giving them all the world. So there's what, 62 member board, is that right, John?
I kept thinking there were 69.
Maybe 69. But that includes,
State
Virgin Islands and Guam and Puerto Rico, and so they really, it's a very, very large organization. Yeah. Okay, let's, about 3 minutes to 12, let's adjourn for lunch, and we'll be back around 1 o'clock.
I'm my right.
What about the rest of us?
Sure, come on.
Somebody played a band all night last night.
Okay, we're going to reconvene. It's now 1:48. We had an extended lunch, so we're ready to get back to our agenda items. The last item that we have that's we've not discussed under new business is discuss licensing of photogrammetrists and GIS individuals. I put this on agenda. We've had it on a couple times, and the primary reason for it is for us to consider whether we want to make it a concerted effort to try to license these individuals. Many states adjoining us have made recent efforts to license photogrammetrists, and that's not a very large number of individuals as far as quantity, but what they do is overlapping with what we do. That's a small group. Now the GIS individuals is much larger, and I think that we may want to consider potentially trying to license some of those folks, because that's the GIS technology for Unicode is Geographic Information Systems, and they have to deal with a lot of survey data in their work, and many states, I know, speak to South Carolina in particular, they have a surveying license for a GIS individual, and it's been very successful. It's also helped them with the GIS community create a better work product that they're dealing with. So I wanted to kind of throw that out forward for discussion to see what you all think, and this obviously would be something that we would have to begin to entertain and formulate as an addition to our statute for licensing individuals. So I'll put that out on the floor for discussion from anyone, and see if we want to seek out information from other states as to how they've crafted their licensing law, and consider the possibility of trying to run it through our legislative process. Okay, let me answer her question first, if that's okay. Photogrammetrists primarily deal with creating maps from aerial photography. And in order for them to do that, they have to have what we call ground control. It has to be survey quality ground control, so that they're able to triangulate information from this ground control in order to create the maps that they create, particularly on the surveying side of things in topography. Is one of the key items that they do. They're also doing, many photogrammetrists also do LiDAR, and I can't remember all of the letters for that acronym, but anyway, that's one of the things that they do LiDAR gives them millions and millions of points on things, so that they're able to get a much higher accuracy level of topography for things that are on the ground. A lot of times they can do it either from a helicopter or from an airplane. But they do a tremendous amount of mapping. And generally, for example, like in Virginia has licensed photogrammetrists under the land surveying umbrella, or it's land surveying dash photogrammetry, and that's what their basically, their basic charge is. Just like GIS in South Carolina, it's land surveying / GIS, and they have that differentiation within their definitions of their law. So that's kind of what a guesstimate on my part, Galen, will probably be somewhere in the 20 to 25 range. It'll be a guesstimate. Because many photogrammetry firms have several individuals that are responsible for the work and they have their license. One we use at home a lot is actually in Virginia, that's TuckMap. And they have several individuals. Who you all might use?
I don't know.
Y'all may use Katera down here, maybe. Continental used to do a lot in Knoxville at one time. What was Hap Holliday's outfit? Was that Cherokee? Okay. Yeah, we have a lot of a lot of them that are out of state that work in state too. So we have an avenue there. In other words, it's not I wouldn't anticipate the photogrammetry side of it would be a tremendous revenue boost from that standpoint.
I wouldn't either.
But it would give the board control, and I don't think that particular, I'm not sure, but I don't think that particular profession is regulated in the state of Tennessee that I know of with photographers, nor is the GIS, and that's kind of I guess that's a sidelight legislatively, being able to regulate a profession, but at the same token, being able to put that profession under regulation so that you do protect the public's health, safety, and welfare. My analogy. With GIS individuals, that's a whole lot more focus. A whole lot. And I don't know how it is for Galen works, but we have a lot of issues with GIS folks here. For example, one area that GIS is prominent in East Tennessee is they've taken aerial photography and they have superimposed, as far as when you look at it, property lines from a tax map or an assessor's map. And oftentimes these lines are really not very close. But the general public perceives these maps, property assessors, to be gospel. Because, well, that's a picture of my deed, and, it shows that the neighbor's driveway's over on me. I mean, right there's my house, and here's the property line. They've created an enormous amount of problems in our area. And a lot of it has to deal with the management of the data that they deal with. I compare GIS to a cake. All you ladies know, make cakes. And a layer in GIS is just like a layer in a cake. And it's just a multi-layer cake. And they basically put all these layers together. Well, the base criteria for this cake is whatever datum that they're using. And that datum really comes from a surveyor. So that's why I feel like that, part of the reason why I feel like that we should be looking to regulate that profession, because the base data has a lot to do with us. And if the base data is incorrect, then you can see everything starts getting shifted and moved around and causes enormous problems.
Yeah.
But if it's correct, it makes everything work better. And municipalities, counties, and so forth, they all have GIS scenarios. And they use them for all types of things, for police, for fire, for utilities. It's amazing how much stuff GIS is interrelated to. And all these, towns and cities across the state that are doing this have individuals that work in that field. And it would be better if they were, in my mind, if they were licensed and properly trained with proper continuing education. If we could, because they're closer to us than most other boards that we would have, if we could reach out, get these people on board, and I think it would be very positive for the state and the public. That's kind of that's my soapbox speech about it. I hope that we can continue to discuss that a little bit and maybe formulate some language.
I think other states have the same problem, the same idea because GIS folks do tend to create sometimes problems that are difficult for us to get arms around you and say, but the data that they give and the data that they produce is taken as gospel when in fact the accuracy is not there.
Have you heard any of this discussed at like the NCWS forums, other states? Have you heard anything like this discussed at the forums at NCWS, other states discussing this issue?
In one of the forums I went to, one meeting said this was discussed, and explained that there's 10% because of the inaccuracies in the data that they have. And you know, if you take somebody working for a utility, and he goes out and he ties what he has to something, what he thinks is a property corner or what have you, and his utility poles are in manholes or whatever it is that he's locating, and they come in and produce a map with property lines, supposedly depicted correctly. But, you know, the distances and everything between their units that they're shooting, whether it's utility poles or manholes or water meters or whatever it might be, that may be very good. But when you associate the property line with it, then you create a real problem. And a problem for the surveyor because they have handed that map out to whomever has purchased the property or whatever it is. And say, well, this is correct. You know, he did it with GPS. So, no, that's mighty nice. He did it with GPS. But what have you done with it with the GPS? Did you know how to handle the equipment when you did it? No. I just have a problem. Perhaps GIS individuals probably should be licensed. Held to some kind of standard.
I have a few questions. I think licensing is like come forward, so I want to make sure that you take the deliberations before looking at legislation. It'll be some of the questions that will be asked by the legislative forums. I just want to bring them up early. How does licensing these two groups protect the public? That'll be one of the first questions they ask. How do these professionals have, or excuse me, do these professionals have an organizational or professional standard requirements currently? Is there anything that we can use to develop that off of? Is there a benefit to the public by licensing them? Is there a benefit to the proposed licensees that we may regulate? How much would it cost to license the 20, 25 individuals, or
registration program. Not make it a license.
Then you can't bring the registration program when you have standards, which would not,
Interior designers are registrations, they're not licenses.
there was no, he was talking about them not having consistency in how to do things. Registration couldn't have.
Well, interior designers, they're no license or registration program. They have their own rules and everything, just like a licensing program. They just don't pay the professional tax. But you're not prohibited from participating in it. You just can't be registered unless you meet all the minimum requirements. That's the weakness of it. The licensing program, thou shalt have a license to do this. Registration, not so much. But only the registrants are regulated. You remember geologists are just registered for quite some time.
So just some things to think about. It's not, I mean, I don't know enough about either of them. I use GIS services. I dealt with many different public records authorities, mostly through the assessor's office is my knowledge based on that, courthouse records and whatnot. But,
We also have to add a GIS professional report.
Just some things to think about is if you have the answers up front, things tend to be more successful. But you know, if you're moving in that direction, those are some questions I would definitely look straight up and down.
You can take some of those concerns to an April meeting, perhaps, and see what other states they've addressed.
Well, Daniel calls the Colonial States Board has crafted a examination for photogrammetry that other states are currently using. So there is an examination that is out there that has been pretty much tried and proved by a national organization. So that is out there in place. As a matter of fact, NCWS is actually looking at incorporating that examination under their umbrella to assist states that are licensing photogrammetry. So that's something else that's positive in regard to one of the questions that you spoke to. So what I'd like the board to do, if we can, is continue to discuss this. I'll try to get maybe Virginia's photogrammetry law and South Carolina GIS law and bring it in and let you all get a copy of that so that we can kind of look at that just a little bit and see if we feel as a board that it's something we want to try to tackle. And that's obviously probably I would think a minimum of a 2-year project. It's not something that's going to happen tomorrow at all. 2 years. Because of the legislative process and all the other departmental questions and answers that need to come forward. And I realize that. But I think it's something that may have some merit to it, and we can kind of work towards it. I mean, just as we're tackling rules, standards, and things of those nature, they've taken time and been pretty successful getting through some of those hurdles. So, this may be one of our next things down the road. So I thought we'd just bring that up and kind of go from there. So.
Clearly, I thought of one other question, which was, although Robert brought actually to them, what other states have this already or in process? And then the other question would be, what would be clear definition for those two types of professions where people would know either in this or I'm not this, or very clearly defining what they are, so that when we enforce it, we know how and everything. Would Google fall under? Is it a non-human being kind of? You can't have just, I know when I see it. You have to have clearly defined. This is what professional GIS agent lots of questions. I
Sure.
didn't, you know,
Sure.
I really thought this one.
Well, good. Glad you had your thinking, Ken. That's right. Well, I mean, you know, I feel like that part of the charge that we face as a board is to be forward thinking. And the only way we can be forward thinking is to do things of that nature, to craft a concept and then work towards achieving it as a goal. And if we run to the wall and we can't get there, then we've not necessarily wasted our time because we've investigated and we're better for what we've learned to help us for where the next task may be. So that's kind of the way I see this world. Okay, let's move on to old business. And the next item on old business is I'll point to Mr. Roberts, status of our rules of conduct.
Well, as I mentioned this morning, those are en route to the Commissioner's office to sign off for permission to file a notice, which should be plenty of time to set a February rulemaking hearing date. So that will probably be part of our February meeting. So maybe a 2-day meeting next time, for sure.
Or a 3-day meeting. Public hearing.
But those rules of conduct, they've been sort of vetted through tabs and everything, which is what we like to do because it sort of minimizes the clamor at the rulemaking hearing. Status of legislative changes, I think we mentioned. We've got our wish list in. We'll know what gets in and what doesn't, I guess, closer to session, which starts sometime mid to late January. I think that's when they go in. We'll start committeeing stuff before then. The bills will start flying in January. The next thing is the policy on continuing education. We're going to talk about those rules. So what's the policy?
Well, where we were at, as I recall, in August, we were discussing how Donna was to look at continuing education as it comes back up at the end of the year again. Primarily, as I recall, relative to out-of-state folks, about their compliance with our rules. And I think the issue there was, for example, let's use Kentucky as an example. Kentucky requires 8 hours of continuing education. Tennessee requires 15. If an individual is licensed in Kentucky and resides in Kentucky, then I think by the way our current law reads, we are obligated to take their continuing education to be equivalent to ours because they're licensed out of state, they live out of state, they practice out of state, but they're also licensed in our state.
Well, I think to maintain your license here, you have to meet our minimum requirements.
Well, see, that's the question. That's the whole question right there. But what I'm going to say now is just opposite. I'm going to say just opposite. If you're licensed in Tennessee and you reside in Tennessee, then you're obligated to make the 15 hours in Tennessee. The key question bodes around that person that's not a resident of the state of Tennessee. That's the key question.
Well, the license is subject to our law and rules, regardless of where they are. If they live in another state but hold a Tennessee license, they have to meet minimum requirements to hold a Tennessee license. Therefore, they would have to meet our continuing education requirements. It would take the 8 hours they have in Kentucky, but they have to still do 7 more hours.
Well, now, I disagree with that scenario from the standpoint, for example, in Kentucky, once every 4 years, I'm required to have an ethics and a standards course. Ethics and standards for the state of Kentucky do not apply. Well, I should say ethics, no. But standards for the state of Kentucky do not apply to the standards of the state of Tennessee. So technically speaking, those hours would not be credible for the state of Tennessee. That's why this discussion is where it's at.
Well, could we we take some of them that do comply. I understand what you're saying, their standards are not ours. So we would just say, okay, you got 8 hours in Kentucky, bring it on. It would have to be relevant to Tennessee. See, a lot of professions.
Now here's what our current continuing education statute says. Let me read this. It says under section 0820-5-114 comedy, the board will deem a registrant to have met continuing education requirements provided herein if such registrant, when making annual renewal to Tennessee registration, certifies in writing the following. The registrant resides in another state or territory and has been recognized by the Tennessee board as having continuing education acceptable to Tennessee. In other words, we can recognize those. For example, if it was North Carolina requires 15 hours. And I think that would fit into this category here. Would that be correct?
Yes.
All right.
Yes.
The second one says the registrant has satisfied all continuing education and registration on that one, requirements of that state or territory. That's the one that I'm concerned about, because the first one talks about North Carolina in my mind, because it's apples to apples, 15-15. The second one talks about Kentucky, which is 8 hours.
Well, I think the check and balance here is in writing the following both A and B, not one or the other. So, okay, you satisfied B. Well, A, if you reside in another state, you have to have continuing education acceptable to Tennessee. Okay, you're fully satisfying Kentucky, but that's not acceptable to Tennessee. You still haven't got A yet. You got B, but you don't have A. And the states you were using that had the same amount of hours as us, if that was acceptable and it satisfied their state, that's good.
Okay, well, that's why I want to clarify this, because she's getting ready to do renewals, and this question is going to come up as it always comes up, and that's why I want to clarify.
I think that you have to do both A and B. A, B is good, you're done in your state, but if you still have a deficit in our state to satisfy A, you got to make that up.
Or our state people, they have to turn in 15.
Tennessee hours should be very correct. But if they get, like Alabama's the home state, whatever their state is, what is correct, but not about Tennessee.
You check with the other state.
They get a certificate, and they'll say approved by Alabama.
That's giving full faith and credit to other jurisdictions. That's acceptable. That's satisfactory.
Well, just to give you an example, of the 8 states that touch Tennessee, Alabama requires 15 a year, or 30 by hand. Arkansas requires 15 a year. Georgia requires 7.5. Kentucky requires 8. I'm talking about on annual basis. Mississippi requires 12. North Carolina requires 15. South Carolina requires 15. Of course, Tennessee's 15, and Virginia requires 8. So we only have like 3 states that require less than what we require.
Missouri.
Oh, I'm sorry. I did miss Missouri. It's under England. They require 10.
But currently, you're checking every person, whether they're in state or out of state, they should be at least 15. And a caregiver requirement, right?
Up to.
Okay, so the current review is 15, everybody across the board, period. Okay, and that's fine. I just want to make sure that we're all on the same page.
We'll take what they got to have somewhere else. The deficits have to be closed out. You got 9 somewhere, you got to have 6 more for us.
So,
That's protecting our own citizens. It's making sure every Tennessee registered.
so we're not going to
business-
ask them to get those hours in Tennessee as long as they get those hours, right?
As long as we accept them, as long as they're acceptable to us. They don't have to necessarily be done here. protect their own citizens when they can show they meet the minimum.
We're also very unusual because from the standpoint that we do a 100% audit. Most states do not. They do a random audit. We do 100%. So that's why it's important that we make sure that we're clear on what we do.
All the programs that I foresee, 100% audit.
Have any engineers?
You're talking about all the programs in the state of Tennessee.
No, not the five, just the five that we regulate.
Oh, well, that, okay.
Engineers are random because they're so many.
I had Steve be at the board, and like, don't know, even these are hard to remember for each of them, at least I know. For the programs that we do monitor, I guess would be land surveyors, appraisers, and home inspectors. Everybody gets audited. 100%. In state or out of state.
Okay, we're ready now for a review of our board policy on the 10-year rule.
Handed out a copy there. It's right here. I'm sure it's this represents what I was instructed by the board last time we put together. And the scribbling, the writing that you see on it, the thoughts that you see on it are from other legal persons in my office. It's like the first statement is to all states licensed land surveyors. I think the chairman said yes to that. All states licensed surveyors.
Correct, yes.
And then the other, the three paragraphs, the same comment. Stricken as may not apply to are not eligible, and it may apply in the other two to are eligible. Those are the only changes that were suggested.
Okay, let's talk about them individually if we can. As I read number 1, it tells me that if you don't have a license to survey, that you are not eligible to be registered under the division if you're in another jurisdiction of Tennessee. Is that correct?
If you do not have a license in any jurisdiction other than Tennessee, you don't have any other qualifying circumstance. And I think our legitimate exemption would have been working for somebody that doesn't, as a surveyor for somebody that doesn't require it, like Corps of Engineers or TVA or some big brother organization. You can legitimately hold the title and work as a land surveyor without holding a license. If you don't have that or a license in any other state, you're not eligible. That's what number 1 says.
Any discussion on that one, David? I'm okay with that.
But I guess we'll just vote on them all together.
Yeah, well, we won't discuss them individually, but we can vote on them together.
Number 2,
I've got real heartburn on that.
any person who's practiced land surveying is defined by our statute under a legitimate exemption, meaning what we just talked about, such as employment by an agency of the federal government not requiring a state license, provide land surveying services and having obtained at least 10 years of verifiable experience in such capacity are eligible for registration under this provision.
Now, let me ask this question. I know it says agency of the federal government, but where does that place us, for example, if a TDOT employee, let's give you an example. John Doe works for TDOT for 20 years. He now retires. He comes in here and he's been surveying for TDOT. That's what he's been working in the surveying department for 20 years. Didn't have to be licensed, but he's a state agency. Now comes in here and he applies for a license. Does this particular bullet point, I remember two here, say then that we're supposed to allow him to set an exam because he's got 20 years working for a state agency because he was exempt from having to have licensure at any point before?
It'd have to be verifiable experience. It means you would have to be able to look at it and see if it's experience that you would accept.
But, you know, if Mr. Waters with TDOT says that John Doe was a good employer, a good surveyor, and he worked on all kinds of different projects for us over the last 20 years.
I think we need more evidence than that.
You know,
Can't
that's
just
kind
be
of what we're going to see. You know what I'm saying?
Yeah, but they'd have to be more than just a draftsman or a rod man or something like that. We'd have to see a resume and letters that describe exactly what they did. And of course, you'd have the right. That means they are eligible to apply. That doesn't mean they're going to be able to. It just means instead of don't bother at all, it's let's see what you have. You worked for 30 years for an agency as a land surveyor. Send us something that shows us that you really know what you're doing.
What's it gonna say?
Maps that he worked on, field notes, resumes, project descriptions, maybe even letters from supervisors saying that he did all these calculations for me and verified them. Whatever the board would feel would show that he knows how to cipher and operate equipment and be released into the wild with equipment for doing plat. And this doesn't get them, you know, I guess they don't have to take the exam.
They don't.
No, this is just, they can apply for a license under the 10-year exemption. Remember the
Yeah.
statute,
Yeah.
category A, B, C, and then the very last paragraph says, practice for 10 years, you're exempt. That's what we're trying to get a hold of here.
What do you think, Aaron?
I'm not in favor of this. Reason. Go back to the time that we asked for a degree program, and I was on that committee. And it was agreed at that time, when the 4-year degree became effective, the law was that anyone that was in the pipeline at that time that had 6 years of experience was off the chart. At the time the degree requirement went into effect, we gave 6 years from that date to get their license under the 6-year or get a degree. And there again, I go back and I look and say, well, this thing got pushed to 10 years. We've discussed this in time past.
And it never went away.
Huh?
And it never went away.
It never went away. And I'm not sure why it didn't go away, but it should have. It was never the intent of that committee for that 6-year rule to continue beyond 6 years. It never, certainly never was the intent to stay longer than that. I'm not sure what board member and membership of the board was that said, maybe we really need to extend this. And I would have thought, well, maybe we need to extend it for 4 years, but never continue perpetually from that point on as a quote 10-year rule for licensure. Consequently, there are things that I think that the surveyors will look at as if they're not professional and don't have a degree. And the reason is because this is basically an apprentice-type program. You continue an apprentice-type program, you never get that professional status. being able to do the same type of project that I had there again. I bring up the subject of drainage, for instance, even though we test on that particular thing, engineers do not, but since it does not fall under quote surveying, it is an engineering function. This rule and this type of language in here allowing this to continue, never ever be able to continue to do that. We'll always have to fall under the oversight of engineers. And, I just think that that we are leaving something in that we've been trying to get rid of for 20 years. I say, well, we should have gotten rid of it 15, 20 years ago when this came about. So,
Yeah, this particular part of the statute has been kind of a problem for Donna, I think, for a while. Because we get these applications, and if you just read it on its face, people say, well, I worked as a surveyor for 10 years, I don't have a license. And this policy is our attempt to give some guidance to our administrative staff when the application comes in. Now, they don't have a license, so they don't have a right to a license, so they don't have to have a rule or anything. We just have to have an administrative policy on what to do with these applications. That's what this is for. That's what the policy is for. So, application comes in under that statute. You look at it, if it conforms with one of these or none of these, we know what to do with it. If it conforms with none of them, we would say no. If it conforms with one of them, then you may apply. If you do, then it's incumbent upon you to prove to this board why we should give you a license under that statute. If you don't think number 2 is a good idea, then we can just take that out. That'll just leave 1 and 3. Now, number 1 involves somebody that already has a license. Number 3 involves somebody that already has a license. So
let's go over number 3 and then talk about it, and then come back and let's compare to all 3 of them and see how it looks here.
Number 3 is any person who's obtained a license as a land surveyor in another jurisdiction under circumstances that do not meet the minimum standards for reciprocity, which is required by 6218.110, and having obtained at least 10 years of verifiable experience in such capacity, is eligible for registration under this provision. So this is the old stopgap. This is somebody that has a license in another jurisdiction, but their requirements are less than our minimum requirement. But they've got 10 years experience as a licensed surveyor. That's what this one is.
That's a different animal. They already are licensed. And
Big O difference.
I'm sorry.
Big O difference.
Big difference. There's a big difference in here. Those that are licensed and those that are not. So if they're already licensed, I don't know that I have a problem with that. Second,
I'll give you an example. I applied to get a license in South Carolina. They reviewed the application, and they found that I had never taken NCAAS, FS, or VS. And the reason being was I took it prior to 1978 in the state of Tennessee, and the state of Tennessee did not administer those examinations. I took an in-state examination.
But you have a Tennessee license.
But I have a Tennessee, I'm licensed in 5 states. And they reviewed my application and told me that they were more than glad to have me come take their examination, but I would have to take the full, complete examination, FS or PS, and then their in-state exam, in order to be licensed in South Carolina.
You said,
I forfeited my $140 today.
now under number 3, having a current valid license in another jurisdiction and 10 years experience, you would get a license in a common, which seems fair.
Well, if the board deems it right, because I mean, that's what the Tommy section says. It says the requirements for registration of land surveyors are of a standard satisfactory to the law.
Your 10 years that you're supplying under would have to be accepted.
Right.
You got your license in some another state, 10 years experience. Here's my license, here's 10 years experience. Look at the 10 years experience. If that's acceptable, then you meet the requirement.
I'm kind of like Galen. 1 and 3 speak to licensed individuals.
Well, unlicensed as far as number 1 goes.
Well,
They don't have any.
oh, that's right, yeah, because it says on and on. I'm sorry. 1 and 3, in my mind, I'm reasonably comfortable. Number 2 really detracts from what I think that we're trying to accomplish. Is that fair?
Tragically, that's probably the most applications you're probably going to get is the old Corps of Engineer guy put in 25 years or 30 years and now wants to retire from the federal government, but he's got another good 20 years in him. He wants to and have his surveyor's license, but he's been doing it all these years, putting dams in and bridges and whatnot. He wants to get a license. That's what this was trying to address, is people like that. But, like I said, it would be a humongous task for them to prove to this board that they had 10 years of full-blown land surveying
There
experience.
has to be a lot of documentation that says that. At least, I would tend to think that there ought to be a fair amount of documentation. Have to go through and review all of that, just to verify that 10 years was that survey.
One thing they couldn't give us was plans with their seal on it that showed that they are in responsible charge of the survey. It have to be something else.
I wonder out loud if after it says of at least 10 years, of where it says verifiable experience in such a capacity, I wonder if we may use some of the language from the reciprocity section that says of a standard satisfactory to the board in that regard. And that would give the board, this probably gives the board discretion already, but I kind of like that word a little bit better.
Yeah, you always have discretion.
It might be helpful if the time verifiable experience, what we think, maybe in a different policy, what would constitute verifiable experience? Like, how would you want to list it? What type of experience? How specific?
Well, that's what I'm suggesting, Nicole, in actually 2 and 3, removing verifiable experience and speaking to a standard satisfactory to the board. That's sort of what my suggestion is. And to keep from having to define, in other words, use language that's already in the statute, because the language of verifiable experiences is not really in the statute. That makes any sense.
I guess maybe, yeah, I understand. I guess I didn't phrase it very well. This is a pre-application policy, something that we would publish on the website
Right.
for people to consider
Right.
before they apply.
Right.
And if it's something that the board has to consider for standard experience, then that couldn't be they would have to apply for you to consider that experience. It would sort of be circular, like, how would you know before you submitted an application whether you even remotely
If the applicant felt like that he had enough qualifying experience to even apply, is that what you're saying?
right, so if it maybe were fleshed out a little bit more as to what it will be required to clearly define their experience, like the board will expect this type of experience submission on this report, or I don't know how you verify experience, but if this is to be published on a website so that people can, a layperson can come up from the outside and go, where am I going to have to submit? If I work for the Army Corps of Engineers, what am I going to have to submit to you?
The board's going to expect that they acknowledge the use of our standards and practices.
think that the intent of this thing is that he can apply and take this exam, but he's not eligible for licensure until he has completed
Oh, yeah, correct.
the exam.
I think just being eligible for something doesn't mean you get it. That just means that you can be considered for it. I think
Just wanted to clarify that, because it just seems like that if he's eligible, that means they're gonna hand him a ticket. Say, here, we punched your ticket, you can go forth and survey, and I don't think that's the intent of this thing. I think the intent is that no, I'm eligible to apply for this thing, whether I get through it or not, or whether I have enough experience to be up to the discretion of the board.
It might be more appropriate in item number 2 if it were going to stay at all, for it to say may apply, but are eligible, to your point, because that sort of does imply that they're going to get something as long as they've done it. So, that's, I do think this, on a completely separate note, this might be the time, since you're going in to change the statute, you're proposing to go in to change the statute so that that computer-based testing is required. This may be a time to just go back and it's been 20 years and you've been waiting. And you know you're going to go through this change in the next 2 years. This might be the time to go in there and act it all together.
If there's a time, now is the time, I guess, because
Let's put it in the package
keep
every
waiting,
year.
keep waiting to do it. Let me ask this one question.
Okay.
Right now, an individual sends his application in, he's gonna apply under the 10-year rule. Might have 10 or 12 guys that have that very thing. If we change what we're doing to use this and go by this policy, not every Tom, Dick, and Harry that has 10 years experience then can apply under this policy. Only those that have experience under a government-run operation, Corps of Engineers, Department Surveying for TDOT, or whatever it might be. Only those that fit that particular category
Are eligible, and that's why I think we need
Actually,
to
TDOT
change
wouldn't qualify, because this is an agency of the federal government. TDOT's a state agency.
Yeah, but we can change it to federal or state.
I mean, if those individuals fit that particular, just that particular group, then you say, well, for the guys out here that are saying, don't get rid of that 10-year rule, okay, we haven't. We've only kept it, but we've kept it only for a narrow bunch. That they may apply to take this test, whether they pass it or not.
And that's why it says are eligible, because you're only eligible if you meet these requirements. If you don't meet these requirements, you are not eligible to apply.
I really don't like it, but that might be the better way to say, okay, the general surveyor population out here, we kept the 10-year rule, however, it only applies if you fit this particular category.
This is how
The rest of you, you're going to have a degree and get through, like, the degree program.
If you're a number one, don't bother.
Yeah.
That's what number one is. Number two, you're eligible if you think you got it. Number three, you're eligible if you have, let me tell you, license 10 years, good experience. That's how the board is going to interpret this statute, which is our statute. You have the right to interpret it. Just like you said, we got it, we're going to keep it, because we have to. This is how we're going to apply it. You're only eligible to under this statute if you're 2 or 3.
As it is today, the guy that works for Corps of Engineers, he has a degree in engineering. He has 10 years experience. And he's been surveying.
Perhaps
He can apply for licensure to take the exam.
occasion that an applicant can get a license in Tennessee without an examination is reciprocity.
Any person who submits evidence satisfactory to the board, the person who's practiced surveying for no less than 10 years should be exempted. Subdivision B1. B1 is category A, category B, and category C.
That just means that they're able to take the test. It does not mean that they get their license.
All those categories involve the exam.
That's correct.
If they're exempted from B1, B1 is all the categories. They don't have to take the
There
exam.
I'm not interested in anything that somebody's not eligible or doesn't have to take the exam. I think that every applicant that is licensed in Tennessee ought to take the exam.
Section B1, wouldn't it just be the education requirement?
B1 incorporates category A, B, C. Category A is get a degree, pass an 8-hour exam, 2 years experience, pass both written exams, principles, Tennessee state jurisdiction. B, 4-year exam, 8-hour written test, PLSIT, 2 years experience, student principles, Tennessee state exam. C is a 4-year degree, 8-hour PLSIT, 2 years experience, pass principles, state jurisdictions. Then you go on to subparagraph C, which is the 10-year thing. If you have evidence satisfactory that you practice for no less than 10 years, you'll be exempted from subdivision paragraph B1. And that's the problem with giving this work. If you meet C, you don't have to do anything. That's what we're trying to solve here. You got 10 years, we'll give you a license. Well, that's what that says, and that's what we're trying to get a hold of. That's what our policy here is
No,
trying
it just
to
says that person's eligible for registration.
Yeah, they're eligible to try.
They're eligible for registration. It just means they're eligible if we approve their application, using that as the criteria. That's what it says. That's the premise of this whole discussion.
Correct.
We want to define, we want this board to have a policy that clearly defines what we as the board think that means,
That's right.
so that it can be published and everybody understands that's what the board says that means, period.
Have you approved anyone based on this and your experience?
Yes. To take the examination, not to just give them a license.
I don't recall in any time other than one individual I think in the past 15 years this board has ever just reviewed their qualifications and said, you don't have to take the exam, here's your ticket.
Virtually all boards that I'm familiar with, particularly in the southeastern United States, have a reciprocity or a comedy section in their law. Very, very, very rarely do they ever give a license to someone, particularly out of state, that comes in with a license without examination.
They're required to take the state-specific exam, because the laws are such different. They're not all, if they were all identical, then if it came from Alabama and they had the same law as we had, I'd say, hey, just exchange license for this concern, but they're not that way.
I just want to know if this category C has ever been applied. Like, has anyone ever gone through to request an exemption to B1 because of what how it reads in C? Has anyone done that?
Oh, you're talking about okay, just the 10-year here. Yeah, we get that all the time. We've been getting it all the time. We're not pleased.
We wish it would go away. It's
Right.
still in the statute.
It's still in the statute, so
That's
we've
what
got to
we're trying to,
create a policy.
we're trying to take that and just keep muddying it down
then when
until
we
it
get
finally disappears.
When we get to the opportunity
It's so
for
difficult,
some
but nobody can
cleanup,
do it.
when we get to the opportunity for some cleanup, we hope to get it cleaned up.
Is it something you get the professional organization behind?
Some would, and some would not.
speak for them as far as if they would give us a organizational nod or not. So, I mean, as far as, board vote, that our vote is, yes, eliminated or no, no, no.
They might give us an affirmative vote, but it wouldn't be unanimous.
See, that's why we have policy, policy number 1. You have a current license in another state, not Tennessee, but the requirements in that state are not up to our minimum standards. So you come in with that and your 10 years experience under C, you're eligible, if your experience is good, to get a license. Normally somebody that would come in here to our state that has a license that's equivalent to Tennessee reciprocity. But this is somebody that's...
Part of the reason that we're including that language in the code is because all states do not require a BS degree. I think there's 26 that does, off the top of my head. So it's a little more than half, not a lot. So we have to be considerate if state A does not require a BS degree, which is what we require, yet that individual has became licensed there and has practiced there for X number of years, so that we're not isolating that individual.
They have taken exams to
from being licensed in our state. We have to have that there in order to accommodate. But what we're saying is, I think what Galen was trying to say was, when our state made a concerted effort to get the BS degree approved for surveyors, the 10-year scenario was intended to cover the folks that were caught at that time saying, okay, look, you now have to have a degree. Well, I've been working for 7 or 8 years, and I'm just about ready to take my test, and it's unfair to me for you now to tell me I got to go to school for 4 years or every X number of time. Okay, so it was intended to allow that group to flush out, so that from that point forward, the degree people then became the applicants and potential licensees. Now, if I said that right.
Yeah, but at that time it was only 6 years, and it got extended to 10 years, and then it just why, I don't know why. It had to have done with the previous board.
I guess when this statute was written, it should have had a self-terminating clause in there.
Well, technically it did. When that statute was written, it said yeah, it said B1 actually said effective July the 1st, 2003, and except as provided in subdivision B2, so forth and so on. So it actually alluded, and then when that changed, the language that we currently have, I don't recall exactly when that language came in, the way it is written in this document that I have here.
We can't ignore it. It's there, and people are going to try to misinterpret it if we don't interpret it.
My recommendation is to not use the policy that goes part of your board. You're already looking at changing the rules, having a rule making hearing once you've gone through for continuing education that you're revising. Just incorporate this requirement as, this language as part of rulemaking, and that way you have it in a rule. Policies are exceptional part of the rules.
Well, you don't enforce policies. Policies are just how we accept applications.
But any policy that restricts a person's ability to gain a credential has been very thinly viewed.
It's not restricting anything.
Well, you deny someone based on. I'm just trying to offer my opinion, experience, and bad things from happening to other policies or other boards. happy for you to proceed. I just think it would actually be more enforcing if it was a rule.
Well, I think probably would be more important to it, the rule. I'm not sure the procedure that we need to go through to get that right at this minute.
Same thing as what you're proposing to do for a change to the education requirements. You're proposing to change the rule, you just incorporate, you can do more than one section at a time in rule. Just incorporate this section.
Think about it this way. D1 has 3 categories that people use to put together an application that this board reviews to see if you're going to let them in or if you're going to grant them a license. Paragraph C is another scheme with the board because it says evidence satisfactory to the board that the person has practiced survey. And what you're doing with the policy is interpreting evidence satisfactory to the board. You have that right. And that's what this policy is for. To screen out people that do or do not have evidence satisfactory to the board. It's a guideline. Who is eligible and who isn't.
The problem with the application for registration section was it was not cleaned up after 2003. That's the problem. Okay? Well, we recognize that, and we recognize that we should clean it up, and it is our intent to clean it up. However, prior to that happening, I feel like that it's incumbent upon this board to create the policy so that when we sit here and review applications, we have a written policy criteria that we can stick to and follow and function on a regular basis as we review applications until such time that statute is cleaned up in the manner that it should be cleaned up.
Policy is intended to keep you from appearing arbitrary.
That's correct. That's what I'm saying.
That's the whole reason that legal section wanted to put a policy together for you or help you do this, is so you have a guideline to conform to the statute that you're commanded to obey until that statute goes away. Okay, we have a statute. This is going to be our policy on how we're going to look at it. That way, when 10 people send applications like, yes, no, 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 you can look at the policy and you'll be able to tell without even looking further. And everybody's treated the same, which is what you want. Nobody can say, well, that guy got one and I didn't. And I got 10 years, just like him. It's like, no, it's not just like him. He has a license in another state. You don't. You both have 10 years, but there's a difference. That's sort of what that's intended to do, to keep you from wandering all over the place. On the other hand, code said, try to keep people from getting a license that might otherwise measure up. You want to be able to have a way to work for Corps of Engineers as a chief surveyor for 35 years. And now you want to get your license.
Right, I think it should be incorporated under rule 0820-1.02 in the application. Clear define if you're going to do something regarding applying for a land surveyor, I would there can be absolutely no question that the law is incorporated into the rule as to how the board's going to apply it. Policy, in my opinion, has to be used for more things like that are internal, like staff will review applications in 1 week. That doesn't limit anybody in any way. That really is an internal restriction on us. We are going to review your application in a week and tell you either yes, you go before the board for review, or no, you don't have the minimum requirements of an application. I
that to me is a policy that we would publish. Or persons who apply under reciprocity. If you move to Tennessee, then if you apply for an upgrade of a credential, then you will go through the same application requirements as anyone else as a resident of Tennessee. So like they didn't have a bachelor degree, we require a bachelor degree. I realize there's not an upgrade to the license, but that's a policy. It's like once you live here, reciprocity no longer applies. It's not restricting you, just making it clear that just because you got the license of reciprocity doesn't mean you get to take advantage of. It's not forevermore. Those are just a couple of policies off the top of my head, but they're not additional restrictions. They're just how staff is supposed to look at them. I think the board, any board restriction or board clarification should be done. That way they have adequate exposure and no one will test them. People can contest the policy. You can't really test an application requirement. It's in a rule. You do or do not meet this requirement. That's my opinion. I'm just throwing it out there. Because I talk too much.
Well, I'll say this, my opinion is, let me take a 5-minute break.
All right, we're going to take a 5-minute recess.
I throw it out there because I wanted you all to protect them as possible in case something ever goes wrong. So I'm not trying to justify, I don't really care. Whatever your decision is, I'm good with it. I'm going to stand behind it. I just want to make sure that I threw it out there so you thought about it.
Okay, it's now 3 p.m. We're going to reconvene and continue our discussion on our policy, or proposed policy. Was there any particular reason, Rob, why state was not included with federal? I just find that kind of odd.
No reason. You could just say governmental entity. I guess you could even say somebody's a municipal surveyor.
Well, I don't necessarily want to open it to everybody's brother and cousin, but
You can strike government and an agency of the government.
You
The
could just say
government.
legitimate exception. You have to demonstrate a legitimate exception.
That was, such as was just supposed to provide an example.
well, I was looking in our statute and trying to grasp that very language, and I hadn't come across it. I know it's in there. I read it, but I hadn't come across where it alludes to that, alludes to the exemption.
I don't know if we have a statute that speaks to that. I think it's just, federal law, of course, supersedes state law. So obviously, if you work for the federals and are not required to have a license to do surveying work, that's what that was intended to address. You graduate from school, or somebody that's actually a surveyor for the federal government might even have a degree in surveying, or they wouldn't have got the job.
They might. Well, I think let's go back to, as I look at the policy, in my opinion, maybe we ought to use the policy as it's written, other than the fact that I think that the last statement down there said, are eligible to apply for registration. I think that ought to be put in there, because I don't want somebody to imply that they think that they are getting a license because they have a degree. And maybe we ought to go with this policy as it's written here.
We can leave it as are not eligible under number 1.
Yeah.
Not
saying just leave the language "are not eligible" in item number 1.
Yes, and it reminds me of a former board member who I remember saying one time about this particular, I think it was Max. How can you get a license for practicing for 10 years? For 10 years of unlicensed conduct. So 9.99 years, you're going to get a consent order from us. But once you get 10 years of unlicensed practice, we'll give you a license. He said the way that it reads just doesn't make any logical sense. But we never did anything about it. Now we're trying to. You can't practice surveying. It's just illogical. You can't practice surveying without a license. And that's what we're trying to address with the policy. Because what he said made a lot of sense. If you're unlicensed, you've never practiced. That's number 1. Number 2, you could have practiced if you had a job to practice under an agency that doesn't require you to have a license. But they may require you to have a whole lot of other stuff. Number 3, you have practiced because you've got a license in another state. But it's not quite enough for us, so you can have 10 years experience. Because you practiced for 10 years with that, I hate to say it, inferior license. But
Yeah, that's right.
But you did practice for 10 years.
Yes, you did.
Now, number 2, you did practice for 10 years legitimately, illegally. Number 1, it's impossible to practice legally without a license of some kind or some other exemption. And that's what the policy is addressing.
Okay, so as we stand, we're going to leave the words "are not eligible" in number 1. Number 2, are we going to reverse our course and go back to may apply?
Or
Or
eligible
may
to
apply?
Are eligible
Are eligible to apply or to make application?
whatever how you want to do that. Are eligible to apply for
Well,
registration.
they're eligible for registration because this is an exemption statute.
No, we are not giving them a license because they meet that.
If they meet verifiable experience, you have to accept it.
We have to accept
Okay,
the
let's-
experience for them to be able to take a test. That's all we're saying. We're not giving anybody their license. The only person we would ever give a license to is somebody that we felt strongly met our reciprocity statute. No one else is being handed a license without examination
In real
and
life.
having met the criteria to get this examination. I said that correct.
Yeah,
In real life, that's the way it's going to be. But just trying to address this statute that says you've been practicing for 10 years, you're exempted from category A, B, and C. The only way you can have practice is if you legitimately and legally practice.
if you have a license.
You either have a license or you somehow
Because if you don't have a license and you're not practicing,
correct.
The only thing it exempts them from is the education. It does not exempt them from the examination.
Anything that's under B1, they're exempted from. They're exempted from subdivision B1. So anything under B1, they're exempted.
If that's the case, we've really been implementing the rule right. That's the case.
People will come in here having done unlicensed activity for 10 years, expecting they somehow qualify for something. That's an error. That's not what this statute even says. Practiced means practiced. I think that means when we're talking about inferior license, license. Evidence that they have practiced for 10 years would be presenting us with a license from another state.
What would you rather like to do?
It's about 10 years. Show me 10 years. If you work for TVA, I don't know what TVA gives you to show that you qualified for the job. I don't think they just hire people off the street. I don't think.
What about that little creature that worked under him? What do you call that? I think I hear one of your license, what do you call that, practicing survey?
I think the only way that you can satisfy C, because it says has practice survey. You can't practice survey in this state without a license.
What do you call them now, you know?
You got a license for practicing.
If
They
you're
don't,
working
they're
under
just-
somewhere, under somebody,
They're just getting experience, not practicing. That's what they're saying. Now, under normal reciprocity, if somebody came in with a provisional license, we would give them a license here. Under C, if you have less than equivalent license with 10 years of practicing license, we can give you a license under C.
without taking the test.
Correct.
That's what that's saying.
Correct.
What do you make them take the test?
That's what I understand.
And if they don't have a license and they haven't got 10 years experience,
But the linchpin, the
what do
important
you
thing,
take a test?
the important thing is has practiced survey. You have to have legit. You have to have a seal that have been practicing for 10 years, or you have been practicing under the federal government or something as a surveyor.
Ask somebody that was not working under him, got here just working. You go up and ask them and say, well, you did better for 10 years, and they're gonna say, what? Practice and
Working for a
survey.
surveyor.
Practice and survey.
Just
Surveying, that's what they're gonna say,
Yeah.
surveying.
It's like apparently you can't say they've been practicing law for 10 years. I've been working for an attorney for 2 years, doing everything they do.
They know it works.
Okay. I think actually the C is a lot more stringent than I think it is because of the word practiced. If it says has been involved in survey, we would be a lot looser.
So, when people say this, it's already got a license, have 10 years experience, and they watch this tape, then we're here saying, we're gonna just give them a license.
They got a license.
Without taking a test. That's what we're saying, that's saying.
If you get a license in Montana, Montana's requirements aren't as strict as Tennessee's, but they have a license in Montana. They have a license in Montana and they've practiced for 10 years with that license.
You're looking at people who come with 10 years experience and doesn't have a license.
They don't qualify.
And we made them take the test. Did we do it right?
Not nothing. You have to practice. You see in Montana, every state comes in, license not quite as strict as ours, license 10 years experience, that would bring them up to see. Give them
we changed the words in 2 and 3 to say are eligible to apply for registration. Where's your heartburn there, Rob?
I think applying is probably correct because they bring us their 10 years. They still have to be 10 years that are acceptable to you. We
Correct.
can reject it.
Correct.
It's like I was saying, state X license. Guy's family moves here. He moves here too. He has his license. Been practicing 10 years in that state. The licensing requirements aren't as strict as ours, but he's got his license and 10 years of surveying with his stamp on plats and all kinds of work product that he brings to show you. You look at it, it comes up to our standards of practice. He's been doing it right as far as we can tell for 10 years. You can give him a license. Do a quasi-reciprocity is what that would be, because they already have a license.
Or we could have them take our examination, which is pertinent because our rules and regulations are different than state aid.
Well, that's why I was saying they've got a license. They have a credential and 10 years of experience that we accept. They can get a license. Or you can make them do whatever else to get it. The same thing would apply. I guess we need to, I don't know what you have to do to be a surveyor for a government agency. I'm sure you can't just walk in and apply for it. You have to have a degree or something, don't you?
No, a lot of them are trained then, aren't they?
It could take years.
That's correct.
And that's almost impossible to do.
It could be an individual that may have gone to junior college and gone to work for Sam. And he had a associate's degree in surveying. And he went to work for Sam or some state as a surveyor, and he was trained to work for the state doing whatever the state has in the new, what have you. And he did so for 10 years. He produced whatever documents are required for the state. Doing highway work, laying out dams or whatever it might be. He would never have had a BS degree. All he had was just an associate's degree. But he's had 10 years of experience. A lot older.
He's moved up to like chief, like he's a supervisor over other surveyors. He's producing a responsible charge. Because he couldn't give us documents with a stamp on it, we didn't have them.
But at that point, just because he has done that for the government entity doesn't say that he knows the state laws and what have you. He's eligible to apply for licensure. And we say, all right, you should take the exam. He says, buddy, and it's yours.
Our Tennessee jurisdiction exam. Take that and pass it, and let you have a license.
I would tend to think that probably would. I haven't thought through the entire fundamentals thing. Obviously, if he's been working for 10 years or more in the surveying industry with the government, he has the fundamentals now. I would hope they would have it down, but I'm not.
Well,
I'm not sure if that's. He may ought to take the entire exam.
it says, once again, they have practiced surveying. Then we go back to 6218-1023, which is our definition of practice of land surveying. Practice means practice. And we have a definition of what that means. They have to have done all of this for 10 years. Now, the guy that applies under 3 that has a license in another state can show us plats with a stamp on it, field notes. And the stamp means he's been in responsible charge of surveying.
I don't have a problem with 3. I think the change in the word mechanics that are eligible to apply for registration, I think that ought to apply both the 2 and 3. There again, practice of surveying, if you define the practice of surveying as one that has a license, and if he doesn't have a license, then he really hasn't practiced
Correct.
surveying.
Unless he's worked under a legal exemption.
That's, yeah, I'm sorry.
Yeah. I was a land surveyor with, Department of Environment Conservation, Department of the Interior for the United States government. I was a land surveyor, laid out mountain ranges, state, federal parks and all that. They can show us that they really did that, was in responsible charge of it. They had a legal job, or that legal title.
They're eligible to apply for registration, which is all right. You take the exam here and off you go. That might be the softest way to get into what we need to do here and still save face with the professional organization and public and protect the public too.
You can just tell them the statute says you have to have practice survey.
Yeah.
Well,
You can't do it without a license.
I still lean a little bit to eliminating the word verifiable and simply saying 10 years of experience of a standard satisfactory to the board.
Yes, sir, I've got that note down. We should change
I
that.
really think we need to do that because I want the board to maintain that control.
The board has control.
And I think if we say it, then it's right there in front of them. It says, the board's got to review my stuff and say it's okay.
Well, they're going to review it to our standards of practice. Your work has to conform to what we
Right.
say you have to conform to. This is what nobody wanted to talk about. So we're a lot of people. Mighty Tim kicked it.
Okay.
Would you like to see it in written format before you vote on it as a policy? And would you like the revisions done?
You want to take care of that in the next 8 minutes? If you are, we'll
By
do
tomorrow
that.
morning.
Or by
It
tomorrow
could be
morning?
done by tomorrow morning, but unfortunately our board council has a board meeting tomorrow.
Where is this document, Rob? Is it your word stuff or Donna got it or?
Well, I can email it to you. Yeah, it's in my archive.
Yeah, I don't,
Let's,
the revisions are minor, but it would be good.
why don't we take another brief recess and let you get that information to Donna and let her change about 10 words and 2 sentences here.
I'm going to change it. I'm going to run new copies if you want.
That's fine.
I'll email it to you. So have future changes.
Take another break.
Yeah, we'll take a little break. We're going to break for just a few minutes here while we get our document doctored.
It's always good to know what you're voting on.
2 and 3.
Oh, okay.
Okay, well, that's an easy amendment. Are eligible to
And I
apply.
think you need to leave
Experience.
the word experience and proof. Had at least 10 years of experience to a standard satisfactory.
So yeah, just
Yeah, I think
delete
that-
the word experience in number 3. There's a line through it.
And then put 2 after. And then put the same statement after. Eliminate verifiable in 2 and then put that same statement after experience.
Yeah, there you go. That'll work.
as amended, item number 1 strikes out the words may not apply and replaces them with the words are not eligible. Item number 2 strikes out the word verifiable, and after the word experience adds the words to a standard satisfactory to the board. Then it also strikes out the words may apply and adds the words are eligible. Item number 3 strikes out the word verifiable, leaves the word experience, adds the words to a standard satisfactory to the board, strikes out the words may apply and adds the words are eligible to apply. Are there any other revisions?
Read number 2 one more time.
Okay. Number 2, going to the 4th line, we're going to strike out the word verifiable,
Okay.
and after the word experience, insert to a standard satisfactory to the board. Then we're going to strike out may apply and add the words are eligible to apply. That's what to be added.
Are you also striking out such a capacity?
No, after the word experience will be the phrase.
Right. To a standard satisfactory to the board in such a capacity.
Yeah, such a
In such a capacity. Yes. In such a capacity are eligible to apply for registration.
Okay.
Okay? Understood?
Sounds good.
If we agree with the dialogue, and there's no further discussion, then I will ask for a motion.
So moved, Mr. Chairman.
Okay. And do we have a second?
A second.
All right, we have a motion and a second. Hearing no further discussion, I'll call for the question. All in favor, say aye.
Aye.
Opposed likewise. And I am proud to say that the board now has a policy in dealing with this situation. And the board will continue in its workings towards legislative issues to keep this on the list and see what we can get to at some point down the road, because all those things take time. I appreciate everybody's comments, direction, and thoughts on this matter, and I hope that this will better clarify for especially Ms. Donna, applicants when they call in with questions, and I know that it will help the board in clarity for reviewing the same applications, and that's what we want to try to do. Okay. The next thing on our agenda is going to be our continuing review of our continuing education section. And since our legal counsel is not going to be with us tomorrow, I want to give Rob an opportunity to speak to anything specific that he may want us to be acknowledged to before we start to work on it.
Have we submitted any of our ideas to TAS? Have we gotten that far? I think when's your next meeting?
Well, is it fair to say, Galen, that when you met with them in September, that you mentioned that we were working on these? I don't know
And
what.
I said that it would be forthcoming for them.
Okay.
That's all I said.
I think what we should probably do is just submit to members of their board, I guess, a copy of this chapter saying we're interested in beginning renovations on this chapter on continuing education and are soliciting comments from your body, and say by February we would like to see your comments in a document that we can discuss.
I think you need to put a time limit on it. I think February is a good enough time.
Our next meeting is 4 months, so that's a little bit of time. I think that would be a really good step to take, because we'll be able to see the questions and concerns of the
See,
professional
Benny's and
population.
President, am I correct?
I think so.
I think he just took office at this last meeting.
I didn't stay for that. Switch over.
Indoctrination.
Indoctrination, no, but I think
Brendan was president.
yes.
He passed president.
But I do think that this will pass on to them. He may even call for a meeting to discuss this, because I don't think they're on schedule for another one. I think they'll be scheduled one in January. I have to ask.
Yes, they'll be scheduled for one January.
I'm sure they will.
Second is the weekend in January.
Is there a way they can distribute it electronically or something?
I think so.
And then they can discuss it in January, and then in February we can have a markup of their concerns.
If I'm not mistaken, I think I have the original Word document for this. If you like, I'll be glad to send you the original Word document. Depending on his email, or send it to you already have her forward it to you.
That'd be a good idea.
That's actually what I would like.
If Mr. Lingerfeld's going to be the one to send out the letter, I would recommend that you all make a motion, second it, and vote to have him write a letter on behalf of the board so that he has the authority to speak on behalf of the board. I know he's chair, but it's still Robert's rules. If one person is going to speak on behalf of the board, it should be done so by the procedural request.
Okay. In order to be technically correct, the chair will entertain a motion to allow me to write a letter or an email, whichever is most appropriate, to send to TAPS. And I think my direction is, I think what I'll do is send it to the board, and then that way she'll be able to send a letter probably to the executive committee, which will probably be the first place she goes. But I'll leave it up to them how they want to handle it.
Explaining that the board is soliciting their input into this chapter.
Right.
And we're
So moved.
Second it.
Now we have a motion and a second. Any discussion? If not, we'll call the question. All in favor? Opposed likewise?
You know what I love about this board basketball? I have a 9-member board that I keep notes on, and I'm always having to say, who did the second? I never have to guess on these. I love that about this board. It's like, who did the second? Well, Miss Mary did the second. Who did the
Well,
first?
the chairman sort of don't know here, so except on legal issues, that's all. Okay, I think what I'd like to do now is see if Rob has any additional comments at this point.
that was my recommended next step
Okay.
of this project.
I think what we'll do is, it says back if y'all will adjourn and come back in the morning at 9 and continue our review of continuing education. If that's all right with you all. And
Just don't have, you have that, would you print off another copy of that for us?
I don't have that like that. They emailed it to us. Well, I did it just like, oh, okay. I thought he emailed it right after he did it.
I can make copies of it.
yeah, just make copies for Sue. Okay.
It won't show black. It won't show red. It'll only copy black and white.
Marvelous.
Screen
State.
tag.
I don't know what's wrong with you.
No, I'm talking about the state.
No state's color, right? There's no color in the state.
We have a color printer. We do not have a color copier. Would you make a copy for me too?
You got it.
You got-
And we can scan in color, but we can't.
You can scan it and then print it in color on your color See there?
I've got a printer, it's an HP, that wide format, and I can scan it and print it in color. And you'll copy in color, and all I have to do is just tell it.
Please
No,
pass
for
your concerns along to the
$300
governor.
copy.
I have to work with the printer they gave us.
It'll just look kind of screened back.
It'll come back as black.
Just grayer than the black words.
Yeah.
Screen.
Well, like she said, she can just mark which ones were red, but I think if he emailed it to you, it's not like you don't have a copy.
Kind of next budget. Maybe we'll have it ready to roll.
Okay, Sue,
Continuing education.
tomorrow you make all the motions, and I'm going to second.
If you can do it all in the next 40 minutes, we can just do it and you're going to take the morning off.
Be here tomorrow afternoon, right?
For the exam.
There's an exam here tomorrow afternoon?
Yeah.
Here? No. Okay.
Oh, wait, it's a hand.
If they can complete it, like
Today. Yeah. I want to get, they should complete it today if possible. And then just go to the exam tomorrow. Especially if you're going to solicit comments in February anyway.
we'll have the comments back from the professional society which we talk about their
I know, but that's what I meant to say, is that you would have additional consideration of the rules in February
I'll meet you.
based on those comments that you received. So,
we're ready for here.
Like 78 days, that is the first big, not the first one, I think, when you come off the interstate. It's the next, it's right there. McDonald's is right there.
It's the first
It's
day.
Thompson, I think it's Thompson something.
It's the first Tennessee Street.
No, you're going past that.
No,
You're
you're
not gonna get
talking
up
about
there.
going past medical.
Yeah, you're going down to 78 days.
That's Tennessee Street, that's
Yeah, but you're not gonna get up there. You got
So
the
the
next.
next one, that's the one where the, what
Is that the Salem? Is that the Salem?
No, the next one, you're
Highway
gonna get all
231.
on 96, it's Highway 96.
Highway
Where you're gonna
96.
get off.
Is that where you say, that's where the handle
Chairman,
Franklin Road.
when you write the letter to TAPS, do you see, when you write your letter, will you phrase it so that they get it to the office at least a couple weeks before the next meeting so that legal counsel has time to?
You don't have to go early into January.
Sometime in January, if they can get the comments to us.
Don't they usually make the first week of January?
yeah, to the
First
first.
or second week, they need, so.
I know, but if you put a deadline in the letter, it gives us
Then
at least a
you
little
can
time
go
to think
after
about it.
Yeah.
Think about the possible ramifications of their comments.
Here's yours.
Thank you.
Here's Gaines.
Look at there, you got color there.
Oh, look at that.
I knew this guy. Look at that in my mind.
All I need is the glasses.
I have a spare set if you need them. Well, if you all don't need me anymore today, I don't know if you plan to come back tomorrow or not. It would be great if you could discuss all of the proposals today, because Robert won't be here tomorrow, and since he's the one who will have to type it up, we probably.
Are you?
I it's just,
You could have other things
to afford you the best opportunity for legal advice. Robert's here in the room for you. It would be best if it could happen today. If it is not possible for it to happen today, then Mr. Joseph can come tomorrow to your board meeting from 9 until however long you need it to be here. But he's not as familiar with your laws and rules.
I don't think we're going to do anything earth-shaking law-wise tomorrow, but I think what I wanted to accomplish was I'd like to kind of go through the entire document and look at what we have amended and address those things. There's 2 or 3 areas that we need to discuss relative to some potential numbers that we've not filled in just yet. I would like to do that. So probably a couple hours or something of that nature, and we'll complete those examinations. So it'll be brief, but I think
to do. And
that's
we
all.
probably don't need Robin, and I don't know if we need any real, I think we've already gone through.
Yeah, everything here.
Everything on here with him being here.
Right. We have proper legal advice from Rob on everything that's in here on the record. And basically what we're going to do is just kind of go back through it and see if there are any bullet points that we've not touched on. If there's any other comments that we may want to consider, things we might want to consider adding. Just as an example, Rob got us the engineer's language relative to electronic signatures, which I think is in this. No, I guess it's in maybe a back lesson. Yeah, that's the root cause. But anyway, there's a couple things that we do need to discuss here for sure and address. And I think that will be fine if Mr. Joseph would like to attend. He's more than welcome. If you want to attend, you're more than welcome. And if anybody else wants to come in, you're more than welcome. So I think we'll speak on these, go through them in the morning. And by the way, for everybody, we'll be in the 3rd floor conference room tomorrow. Correct, Donna? Correct. So it's all right. We'll entertain a motion to adjourn for the day, and we'll reconvene tomorrow at 9 a.m. Purpose and direction strictly on the rules of continuing education.
So moved.
I second it.
Who's the second?
All in favor, simply leave.
Who said what? Who said what?
I second it.